Okay, I'm back. Hello. Hello. Thanks, you guys, for indulging me. I had to go be a mom for a couple minutes and pick somebody up. I have 5 kids, and sometimes you got to do what you got to do. Kids got to come first, always. So I had the schedule for 9. So I knew it was going to be a couple of hours, and then I had to do the pickup. So now I'm back. So we just scheduled it for 10:30, and in Eastern time. I'm in New York, so thanks for coming back and hanging out with me again because I missed you while I was gone. Jules sent me something interesting. Hi, Jules. Thank you for sending that to me. Do you want to look at that first? Today, they loaded up the court file in the Kowalski case with a whole bunch of trial exhibits. And so this was something that is in the court file. And we're going to take a look at that in just a second. I'm just going to wait for some people to come back. Yeah, late night snacks. Late night snacks. Thanks, Paul. He always sends everyone some virtual snacks. Isn't that nice? Isn't that nice? I didn't change it. I just had to go be a mom. So I came on for half an hour at 9. Now I'm back. How late do I stay up? I stay up. It's the only time I get to myself. I'm for like 2, 3 a.m. So I'm a night owl. That's why I have mods that are on the West Coast and in Australia, because you never know. You never know. My schedule changes. So like the wind, I'm like Mercury. I'm always moving, always moving. I always got to be somewhere. And I hate being late. I hate being late. That's a pet peeve of mine. I am always on time. So yeah, I really hate being late. It totally stresses me out. Somebody has a question about a hold fee on a QVC thing. I don't know. I don't even know what that is. Is it a debit account? Let me see. I will address that question. Hold on. Let's see where that is. Hold fees are a very important subject. I need Melanie to address this, but I don't know where the question is. So let me go back. Person who does my shopping usually said he never had noticed one before. I'd never heard of it myself until dealing with QVC. They have money frozen on your card. I know that the hold fee is sometimes they seem illegal. You know how when you go to a gas station, well, here anyway, when you go to a gas station and you pay with your credit card before you pump your gas, it will put a hold on your card for something like $200. And then after you pump the gas, then the hold comes off and it's the actual amount of your gas, like $37 or whatever. So I don't know. It's an item from QVC that you bought. I mean, like if you buy something from Amazon or at most online retailers, they charge you for it before they even send it to you. So sometimes if you order furniture, let's say, remember during the lockdowns when it took so long to get anything, you could order furniture and they bill your card right away and they don't ship your furniture for like 6 months, which I think is also ridiculous. How about don't bill me until you're going to ship it? So I agree with you. It may be different for a debit card. Same thing when you check into a hotel. They will put a hold on your card for a certain amount of money, and then they'll release it when you check out, depending on what your bill is. So it's pretty common. And I mean, unless it's something that's going to take a really long time, usually they'll just charge you for the thing, right? I mean, does that explain? Usually they just charge you for the thing that you're buying right away, regardless of how long it takes to get to you, which I don't think is fair. Maybe don't shop on QVC. I use Amazon for everything. Comes to my house 3 times a day. It's crazy. Cat food, laundry detergent, whatever I need. It takes longer for me to go to the store than it does for Amazon to deliver it because we have a warehouse near here now. So everything comes next day. It comes in the morning between 4 and 8 a.m. Certain things. So I don't know. I don't know what Walmart's doing. I don't know. You mean like for online shopping? Yeah, Tonya, I agree. Tony says, I was recently scammed by a website that looked legitimately like a real QVC website. Be careful. The item was posted on a Facebook ad. Yeah. Don't buy from QVC. Don't. Just, you know what? Boycott them. Tweet about it. That's the quickest way to get a result from any big corporation, whether it's Delta Airlines or a newspaper or whoever's attention you want to grab. Tweet about it. They will get to you right away. They do not like tweets that are not positive, towards their company. Yeah, Susan, maybe we need to use more cash when we can. Don't buy from Facebook ads either. Everyone's got their tips now. Everybody's got their tips. I know. I don't tweet either, but I tweet when I'm angry about something, or when I'm angry about something, I go on Twitter to see who else is mad about it, to see if I'm crazy. Because I often say to my viewers here, I think I'm in the Twilight Zone sometimes. Please tell me I'm not in the Twilight Zone, because I just feel like this should be so obvious, and apparently it's not, because I feel like I'm in the Twilight Zone. Yeah. Oh yeah? Shy Gal 8. I work for a large retail online store. I'm a manager in customer service. The fraud is insane. No, that's really interesting to know. Are you being a whistleblower on your company? We won't tell you. We won't tell anybody what company you work for. Yeah, that Sharon. Yeah, the pandemic definitely upped Amazon use. Yeah, and they're in trouble too, because they jacked up all their prices. Because really, they had a monopoly. Nobody was allowed to leave their house, right? So they had to buy from Amazon. Amazon artificially inflated their prices, and I think there's a class action lawsuit against them now. That is crazy, Donna. I don't even. I really don't. I don't use it. I really don't use it. I think it's M_ESQ. I think. I really genuinely don't know my Twitter handle. I'm calling it Twitter forever. Just I'm calling it Twitter forever just because I want to. I'm never going to get on board with the whole name change of X. It's like New Coke. It's like, why do you got to change it? It was fine. Everyone knows it's Twitter. You call it a tweet. What do you call your tweets now? X's? Like, I'm going to go X something? I don't even know. I never thought there was anything that I had to say that wasn't important enough that I could tweet it out there in however many characters you were allowed to tweet it out, 140 or something. And, who cares what I have to say in 140 characters? I go there for breaking news. I mean, I got to talk for 2 hours to make a point. I would rather sit here for 2 hours with you than, try and get something into the 140 characters that anybody would care about. I don't know. It's just not my thing. I like Instagram because Instagram used to be like, pretty sunset pictures. Or, if you were researching something like narcissism, you could go on Instagram and find all kinds of information and memes and, inspirational sayings. How many of us have a degree in narcissism from looking it up on Instagram? And that's another thing too. If you find yourself running to the internet to look up certain disorders, you're probably with the wrong person. So that's it. That's it. All right. So we have some of our people back. Jules sent me something that was in the document dumped today in the court file, and it's an affidavit of Jacqueline Henschke, right? That's what you wanted me to look at, right, Jules? And it's sort of just in the middle of an exhibit. So let's take a look at. I don't know if this was admitted into evidence. If anybody knows, let me know. But let's take a look. Okay, this was in the document dump today, and this has the caption of the case. This was filed on April 5th of 2023. It looks like it was faxed. It looks like a fax. Yeah, fax numbers. People still use fax machines. Sometimes I say to somebody like a doctor's office, can you email that to me? No, I have to fax it to you. I'm like, it's not 1995. I don't have a fax machine anymore. I don't have a fax machine. Can you email it? Nope. That must be a HIPAA thing. They can't email it to you. Doctor's offices. Like, what is that? Fax. I can fax it to you. Or you want me to fax something to you? No, I can't fax something to you. I can email it to you. I can take a picture of it with my phone and email it to you. But I digress. I know, so 90s, but so many people are still stuck in the 90s, and lawyers are one of those people. You know how long it took for my law firm and me to agree to get a computer on my desk? It was years and years and years. I think the lawyers are always the less technologically advanced people because we used to like to dictate with a little dictator machine. It's like a little tiny tape, a little tiny voice recorder. And my secretary was an amazing typist. She was typing like 100 words a minute, and she would rather listen to me talk on a dictaphone tape and just type it. So I like it. Oh, thank you. You like my earrings? Thanks. I changed them since before. I like these too. I think they look good on camera. Yeah, Teresa, I can fax over the web. Like I am going to try and figure that out. I can barely run StreamYard by myself. Jules, I am not notorious. I don't want to be either. Oh, so okay. All right. Let's not even highlight your comments. I don't think you wanted to be either. Look, you're on TikTok, right? You enjoy trials. I'm just gonna guess that you are someone who enjoys trials. You became very emotionally attached to this case, like many of us have. You probably happened to live near where the courthouse was, and you thought, okay, I'm gonna go down to the courthouse because I want to see what's happening over there. And then you became emotionally invested, just like all of us. Or as the defense firm would say, improperly emotionally invested. It strains credulity how invested we became in this trial. Let me see if I could. All right. Just strains credulity. I mean, that's all I could say. Maybe. Is that better? All right. Let's see here. I don't know. Okay. Here it is. I'm going to read this to you in my best ASMR legal pleadings voice. Here is your nighttime stream for today. Today is Wednesday, November 29th, for posterity. This is an affidavit of Jacqueline Henschke, signed in the state of Florida, county of Duval. I, Jacqueline Henschke, being duly sworn, do hereby depose and say that I make this affidavit based on my personal knowledge of the facts and circumstances herein, and say, 1, I am over the age of 18. 2, I am the treating psychiatrist from Maya Kowalski for approximately 3 months at this point, and have seen her on multiple occasions during that time, the last time being last week. Okay, so this was trial exhibit number 2011-008. 3, I'm aware that the defense in this case is requesting the 5th deposition of Maya within the next 60 days. 4, Maya has been aware of this, and we have discussed her reaction over the course of the last 2 visits. 5, I am aware of the incidents during the last 2 depositions which have caused her extraordinary stress. These include an incident where the defense counsel left a photograph of her in a bikini on the screen for more than 5 minutes and appeared to be staring at it as he questioned her. Really? Was it Hughes doing the deposition? Is that what you were telling me? The second involved repeated unnecessary questions concerning her mortality and specifically her reactions to the fact that CRPS may in fact kill her early in life. There have been, according to Maya, multiple instances where she had an emotional breakdown during these depositions. That doesn't surprise me, if this is what was going on during the depositions. 6, my opinions are as expressed in the letter I attach here too as Exhibit A. The opinions expressed therein are to a reasonable and medical probability. 7, I have been advised by Maya and her attorneys that at this point, litigation in this case has been ongoing for over 5 years, both in the underlying shelter action, which ended in the spring of 2017 after her mother's suicide. It is my opinion, to a reasonable degree of medical, and that will say certainty that which is redacted, clearly documented in the records. It is my opinion, to a reasonable medical probability, that further intense questioning without any means of controlling the without any means of controlling the questioner, as would be the case in open court, can and will result in a probability of relapse. Further affiant saith not, as if we're in the Renaissance period. And then she signed this in April of 2023. Is there more to this? Okay, this is, and it was notarized. So this is sworn. It was notarized. Actually, it was signed on February 8th of 2023. And then the Exhibit A letter is redacted. See, Jules, when you sent this to me, I opened it and I'm like, why is it black? Did they block it? I can't see it. I can't find it. And then you kindly said to me, scroll to page 8. What say you, my friends? What say you? Cat lady. And she did relapse after that deposition. Yeah. So they were on notice that what they were doing to her is going to worsen her CRPS, flare it up. Was that out of Banana Slime Bowl, lawyers like the defense team is the reason I stopped being a litigator. It took me 25 years to stop being a litigator, but I feel you, and I'm much happier now. I'm much happier now explaining the law to all of you and commenting on the law, and being a mom of 5 and a working actor now that the strikes are over. But it does suck the life out of you. I don't know how old you are. You look very young in your profile picture, so you got out early. Good for you, but it does. It is like, it sucks the life out of you because you fight constantly all day long. All day long. Jules, she spent 5 days in the hospital because of it, because of the 5th deposition, or because of one of the other depositions. I believe it. I mean, he left a picture of her in a bikini up on the screen for 5 minutes and was looking at it. Was he in the courtroom at all? He's the one who talked about isn't he the one who mentioned bus stop people? Wasn't that his quote? McRae, is there any reasonable purpose for a depo to include a picture of a minor in a bikini? Oh, just to show that she's perfectly fine. Well, you must be perfectly fine because you can put a bikini on. Listen to Lauren, they tried to break her like they did her mom. Yeah, Ariel, the black docs are redacted. Yep. You do have to keep positive energy around you. You do. 100%. What do you mean? Did my internet freeze? Hello? I'm here. Are you all here? Y'all here? He was? Oh, he was. The pudgy guy, the bus stop people guy. He was there every day. Older? Younger? Interesting. Well, I guess they tried to beat her down in the depositions too. Widget, I know there has to be defense lawyers, but I could not bring myself to work for the public defenders. I feel better working for the prosecutor's office. Well, that's the criminal side. So on this civil side, I have a lot of very good friends who are defense attorneys. They do a great job, but they represent big corporations and hospitals, and they're necessary. And they're some of my best friends, but we're on different sides. And I think it takes a certain personality, just like it takes a certain personality to be prosecutor or a defense attorney. Some people say they could never ever defend someone that they knew was guilty. Some people say everyone deserves a defense, whether they're guilty or not. And I am a firm believer in the Constitution and procedure and the rules of evidence. And so my opinions will shift based on the case, but I am always a constitutionalist, and I'm always, I think procedure is very important. And I will give you my opinions, and you may not like them, but I am never going to lie to you. I'm always going to tell you what I think, and I'm always going to tell you the truth. Okay. So now we are going back to the motion that we started to cover last night. And that motion, again, was made by the defense. And the motion says the following, in a nutshell. Judge, the jury was wrong. The jury was wrong as a matter of law on every single count that they found us liable on, Judge. So therefore, we need you to reverse that decision on every single count. That's called a directed verdict. Just reverse the jury's decision and say that we won. But if you don't want to do that, Judge, then what we think you should do is give us a whole new trial, because there's so much evidence that came in that we disagree with that never should have been let in by you as a matter of law, because you made mistakes, Judge. Therefore, we're entitled to a whole new trial. But if you don't want to do that, then we at least think that you should reduce the amount of every single monetary award, because all of them were so outside. It should shock your conscience, Judge, how big these awards were, and therefore you should reduce them all. And if you can't figure out a number, we're going to tell you what number we think they're worth. But really what we would prefer is if you just directed a verdict for us and threw the case out. Under Florida law, that is the procedure. They must go back to Judge Carroll to ask for this relief. They cannot go right to the appellate court. Somebody asked yesterday if the appellate court has a jury, and they do not. The appellate court is a panel of judges. I don't know Florida's system, but here in New York, it's 5 to 7 judges that sit on the appellate division, and they all discuss it, and they call you in for oral arguments, and you go in there and you it's not like you get to make your own argument. Like, they ask you pointed questions, and you better be prepared, and you better know all your cases and what they say and what they stand for, and then they render an opinion here in New York. So in New York, our lowest court in New York is the Supreme Court. It's kind of opposite. Then there you have the appellate division, which is the mid-level court, and then you go all the way up to the Court of Appeals, which is the highest court in the state of New York. And after that, I guess you would go to the U.S. Supreme Court, if you can get that far, if they take your case. Okay. All right. Everybody got that? Now, listen, here's another thing. I know we are all very emotionally invested in this case. I know that my viewers, so many of you found my channel, my show, as a safe place to watch the coverage or my breakdowns of the case. We didn't do it live, but we did it not every night, but we did it occasionally. And I know that you found it a very safe place to watch the stream, because so many of you are CRPS warriors. So many of you have suffered with CRPS, or have a child with CRPS, or a parent with CRPS, and you are warriors. And not only CRPS patients are in my stream, but also patients of other chronic pain disorders that are very difficult to diagnose. And many of you have been medically and emotionally gaslit for most of your lives, by doctors even telling you that you're not really in pain. There's nothing really wrong with you. It's psychosomatic. And so my moderators are the best on YouTube, and I'm not afraid to say it. And they kick out the bullies. And this is a very, very safe space. So feel free to introduce yourself in the chat. Everyone is very friendly here. I do not like the cursey words and I do not use them, but this is a very kind place. And I think you're going to like it here. If you unfortunately suffer with a pain disorder, you are going to find very like-minded souls in this chat. Priscilla, congratulations on becoming a new member. My membership is called Melanie's Little Cupcakes, because I am not a cupcake, just like it says right here, because that pink sign that you can't read says you cannot make everyone happy. You are not a cupcake. Can't make everybody happy, but I can make all of you happy, and we make each other happy. And we absolutely 100% welcome respectful debate. But once people start bullying and being nasty to each other and attacking personally, that's it. You're gone. You're gone. You're just gone. And you don't want that. So just guide your actions accordingly, and we'll take it from there. Okay. So we last night got up to page 79, and now we are right at the part where they are going to start talking about Kathy Beatty and the battery for her other touchings. So without any further ado, I think it's going to be easier for me if I try and move this back over onto this page, but onto this screen. I don't know if that's going to work. All right. I need a techie. I need help. All right, here we go. And I'm going to read it to you and just see if I can find a better layout here. All right, because then if I highlight comments, we can still see them and you can see me. All right. Everybody ready? Take a deep breath because this might be hard to hear. And just remember, this is just their opinion. And this does indeed happen in every single civil case. Every single civil case with a large verdict against the defendant is appealed in this manner. It is not uncommon. They are not being just dirtbags by doing this. This is what they do in every single case. But the way they're going about it might be a little dirtbaggy. And the way that they are gaslighting in their verbiage and their phraseology is not the way I would handle it. But this isn't my case. We have to deal with the papers as they are dealt to us. Okay. So last night we left off with the false imprisonment claims, and now we are looking at the battery claims. And here's what they say about the battery claims. Maya Kowalski testified that in the chapel and at other times, Catherine Beatty gave her unwanted affection, including hugs, at least one kiss, and sat her on her lap. She claimed other touches that were painful. This claim only involves alleged batteries by Ms. Beatty, and it does not involve a claim arising to the level allowing for punitive damages. This is their opinion, remember. Ms. Beatty testified that she did sometimes give Maya Kowalski affection when she thought the child needed affection, and that she believed it was professional to do so on those limited occasions. She claimed that she held Maya Kowalski on her lap after the child was very upset that the dependency court would not allow her to go home for Christmas. There is no evidence that Ms. Beatty spanked this child for any reason. I'm sorry, was there a claim of spanking somewhere that I missed? Did she claim that she was spanked? I don't think so. They just being hyperbolic? Like, oh, be glad we didn't spank her. Like, we didn't keep her in a dungeon in the false imprisonment claim. It's not like we handcuffed her and kept her in a dungeon or anything. There's no evidence that she slapped her, whether for discipline or out of anger. Oh, congratulations on not slapping her. Kudos to you, JHACH. Maya Kowalski, at least by today, clearly does not like Miss Beatty. She was the face of Johns Hopkins for Maya Kowalski because she was the most experienced social worker that dealt with children in DCF custody. She was the bearer of bad news whenever there was bad news to deliver. It's understandable that a child would not like Miss Beatty, even though Maya appeared to like many of the other members of the staff. Hold on a second. It's like I rewind all the time because I just cannot believe what I'm reading. Okay, so you're admitting in your papers, defense counsel for JHACH, that she was the face of JHACH. Kathy Beatty is the face of your hospital because she was the most experienced social worker that you had that dealt with children in DCF custody. Okay, hold on a second. It's like the fox guarding the hen house. Are you kidding me? Are you kidding me? I wouldn't have that woman answering phones in the lobby of my law firm. That's what a bad impression I think that woman makes on anybody. That's the face of your hospital? Wow. There's a claim that she hit her on her legs. Jana, sorry, I just threw up my mouth a little. Yeah, stepbrothers. Oh, we were on Office Space the other night. Wow. Okay. She's the face of your hospital because she's the most, you couldn't find anybody better than this woman who, by the way, was disciplined for asking another employee if she wanted to go outside and presumably have some sort of a fist fight because she was overworked. And I think, wasn't there another arrest in her file somewhere for some sort of CA? And this is the best you got? Wow. Wow. It's understandable that a child would not like her. I have news for you guys. Hunta, Shapiro, listen up. Nobody liked her. Nobody liked her. Nobody thought it was beyond the pale that Maya wouldn't like her. Nobody liked her. I don't care how you tried to rehab her when you brought her in to testify live, but in her depositions, she emanated a vibe and an aura that all of us picked up on, every single one of us. And this is who you're putting in charge of a 9 or 10-year-old child? And you think that that's perfectly acceptable? Oh, we'll see how far this gets. She appeared to like many other members of the staff. How many? I think there was one nurse that was nice to her, and she was nice on the stand, and we thought she was nice too. Psycho mom. Psycho mom times 4. I have 5. I win. Beatty is the true face of DCF. Yeah, except Beatty was a hospital employee. They're admitting that she's a hospital employee. So, yeah, wait, did they say she was the face of JHACH for the children in DCF custody, but nobody didn't like her. Nobody didn't like her. Nobody liked her on this channel. There is no evidence that Maya Kowalski received any medical treatment in the past for these touches. There's no evidence that these touches were a substantial factor in any PTSD from which Maya Kowalski may suffer. There is no claim that these touches aggravated a pre-existing condition, and no such jury instruction was given. Okay, but that's why we call the jury the finder of fact. So it's up to the jury to decide whether or not there was a battery, and there was evidence of that, and Maya testified to that. So, don't mislead the court with your mischaracterization of the actual evidence, because we're talking about battery now, which is an unwanted touching. For these alleged batteries, because, they don't believe it really happened, because, they just don't get it. The jury awarded a total of $19 million in compensatory damages to Maya Kowalski and $1,000 to her father. Well, to me, that shows a well-reasoned decision. The compensatory award included $8 million for economic damages in the future and $11 million for non-economic damages. So when they say non-economic damages, that's pain and suffering. And economic damages are either lost income or medical bills or something that's tangible. So for these battery claims, they are asking for a renewed motion for a directed verdict and a motion for a new trial based on a verdict against the manifest weight of the evidence. It is the defendant's position that even Maya Kowalski's version of these events creates no question for a jury on whether a reasonable person would find these touches were offensive under like circumstances. Okay, I think I've got a lot of reasonable people in the chat. There's about 546 reasonable people in the chat, I'm pretty sure. What say you, as a reasonable person? Would you find these touches offensive? If you were 10 and you were being held in the hospital against your will, and this woman, and we're just talking about the touchings now, put you on her lap, kissed you, hugged you, and touched you in a way that was painful, would you find that to be offensive as a reasonable person? Put a Y in the chat if you think it was going to be, if you think it's offensive. Put an N in the chat if you would not find that offensive as a 10-year-old girl who wasn't allowed to see her mom. LB says, I'd find her even looking at me offensive. Got a whole lot of Y's here. Psycho Mom, very best. Love Pink, Colleen McBee. Yes, Janelle, touching was offensive. Yes, Jesse. If they were given to me by the person who told me I couldn't go home for Christmas. Yeah. Just, rub salt in the wound and then tell me that you want to be my mommy. and that my mother's in a mental institution. But we're not talking about that right now because that's not a touching. We're talking about just the touchings. Margaret, absolutely. These touches were offensive. Sounds like grooming besides, yeah. I mean, right after you were deliberately separated by your parents and isolated? Yes. I don't see anybody in the chat, and you are all reasonable people. C. Taylor, as a reasonable person, I would most definitely find these offensive. So I don't know who they're getting their polls from, except for the threads on Reddit that were probably orchestrated and formed by minions of JHACH and their spouses and or relatives. Clarabella, people don't expect to be battered in a hospital that's supposed to take care of you. How was she supposed to seek treatment when she was already in the hospital? Great point. So I think that we can say that we disagree with this argument. The defendant realizes, okay, so that is the legal test for battery, whether a reasonable person would find these touches offensive under like circumstances. I think we've established that. We think that they would, as did the jury, because the jury is the finder of fact. So it was up to the jury to decide whether the jury thought that they were offensive. The defendant realizes that reasonableness is typically a jury question. Oh, well, thanks for conceding that point at least. But the circumstances here involve a child who cannot receive physical affection from one parent and only occasionally can from her father or brother. The plaintiff claims that this child needed an advocate in the hospital, but when a trained social worker believed the child needed comforting, the plaintiff claims that acts of affection and comfort were something a reasonable person would find offensive. Holy traveling Mary. Holy traveling Mary. Did they really just say that? Well, but you're saying that she wasn't allowed to have her mom. So we tried to comfort her because you're saying that she needed comfort. So that's what we had, the face of our hospital comforting her. Are they really making that argument? Respectfully, a reasonable person would find it offensive for a social worker not to give some affection to a child in this context. A female social worker placing a child on her lap when the child is upset does not rise to the level of a battery. I know that we have some social workers in the chat. I know that we do. And this is a children's hospital. And you are telling me that you think that that is the standard of care for a social worker to kiss and hug a little girl? Hello, Julie. This is the current motion. This motion was filed on Friday, but the court was closed, so it did not drop until Monday. And then we were going to cover it on Monday, and then we got sidetracked with the plaintiff's response to the juror motion. So we started this last night, and it's 144 pages. So we got halfway through, and then we're back tonight on the other half. But this is defendant's motion to throw everything out, get a new trial. These are all the reasons why they think the judge was wrong on the law. And for this count of battery, they think that it's totally acceptable for a female social worker to put a little 10-year-old girl on her lap and hug and kiss her because she deserved to be comforted. They are actually saying that they think that this is the standard of care that JHACH should absolutely be giving all of its young girls. The fact that they call her the face of the hospital, therein lies the problem. Thank you, beautiful messy ball. And thank you, Matt Bond. How are you? We haven't seen you in a long time. Thanks for your super chat. Are they trying to destroy what little reputation they have? Gotta be honest, when I was highlighting this, I didn't give it a whole lot of, I wasn't really deep, like thinking about it the way I'm thinking about it now, but this is yes. Like, I don't know if they're trying to destroy what little reputation they have, but if they didn't already do that with doxing juror number 1 and his wife, then I don't even know what to say. I don't even know what to say. What is wrong with these people? And then there's right, Kirsten. I thought she said she didn't do that. So did she do it or she didn't do it? Oh, hell no. It's not appropriate. Oh, hell no. Purple Prose is not about CRPS. It's about social workers stepping on parents' rights and harming families. Yeah, both. But I think it's about both. And that is one thing that we said, that we thought this trial had so much public awareness and public interest. And the two things that we were trying to do here on this channel was to raise awareness for CRPS and CRPS research, and for other patients of chronic pain disorders who are medically gaslit their entire lives. And we have some Team Maya merch that we made, and all the proceeds from that are going to go to CRPS research. And also to bring awareness to the fact that, yeah, you can be admitted to a hospital. Your child can be admitted to a hospital, and the hospital, based on false allegations, by the way, of a psychiatric disorder of an adult by a children's hospital, can have your parental rights stripped within 1 week from admission. That is really freaking scary, and I think a lot of people had no idea that that could happen. And this is not the first time that they have done this, and this is not the first time that Sally Smith has done this, and there will be more trials to come because Greg Anderson's firm represents them. That is crazy. Goodbye, Kim. Get to sleep. Yeah, it's scary as all get out. And I have 5 kids, so somebody is always in the emergency room, right? Or used to be before urgent cares were a thing. And if your child ever had a fracture, I remember one of my older kids, my 2 oldest kids were little at the time, and they were like roughhousing in the yard. And so one of them had a dislocated elbow because the other one pulled them up or landed on them or funny, and went to the emergency room and were questioned like, and they have to, I get it, they have to. It happens all the time. They always take your child outside of your presence and they question your child about their injury. If your child has a spiral fracture of the femur or something, which can happen if you're dancing on a rug and your leg catches and it twists, any kind of a twisting injury, this dislocated elbow is often a child abuse injury because they call it nursemaid's elbow, from when like a nanny would yank on a kid's arm. And they're very, very careful, and I get it. But this child did not have physical injuries. She had a working diagnosis of CRPS in the hospital record. In their computer, they installed the port for her ketamine infusions. It's beyond. It's beyond, and it's freaking scary. Hello, Uncivil Law. How nice of you to join. It's freaking scary. So yeah, it's okay. The child needed comforting, and now you're going to be mad at us because we think that was totally appropriate, and we don't think any reasonable person would find that offensive. A female social worker placing a child on her lap when the child is upset does not rise to the level of a battery. But I thought she didn't do it. Are they conceding that she did it? Or are they saying, we don't think she did it, but if she did it, it wasn't that bad? And if it was that bad, well, she was overreacting. It's the narc's prayer. Maya Kowalski claims that Ms. Beatty told her that she wanted to be her mother. Assuming that testimony is true, and Ms. Beatty's testimony is false, that statement is not a battery, and it did not involve a touching. It would have to rise to the level of extreme and outrageous conduct intended to cause Maya Kowalski severe emotional distress, even to be relevant in this case. Wouldn't it? Wouldn't it rise to the level of extreme and outrageous conduct? Is there anybody here who thinks that it's not extreme and outrageous for a social worker in a hospital to say, I want to be your mother? And then to say also your mother's in a mental institution and that's why she can't come visit you? That's not extreme and outrageous? If that's not extreme and outrageous, then I really don't know what is. Give me an example, Hunta. Give me an example. Hospice Jess, thank you for your super chat. As a hospice nurse, I have boundaries comforting children whose parents have died. They don't want me touching them. I sit with them in space and silence. They want someone they know how to comfort them. What a special job that you have. My mother is a volunteer at hospice. She has been for many, 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 many years. And when my father passed from ALS, which is another horrifying disease that nobody should ever have to suffer from, he went into hospice care. They have a hospice care in here that's like a hotel. And the hospice, the people who work at hospice, the nurses and doctors, are some of the most caring people that I've ever met. Like, that is a really, really special occupation. So thank you so much for what you do, because you bring comfort to families who are going through the last moments with their loved ones. And that's incredible. So thank you for that. Okay. Accordingly, the defendant was entitled to a directed verdict on this claim at the end of plaintiff's case. Defendant's right to receive a directed verdict is even more obvious now that all the evidence has been heard. Yeah, it's obvious to who? It's obvious. It's obvious. It's obvious to nobody but you. That's who it's obvious. I can't even we don't even need to go any further with this because it's just so ridiculous with this claim. Okay. They're saying that the manifest weight of the evidence shows that these touches were not legally offensive, as opposed to morally offensive or just all around offensive. This claim is admittedly a claim based on the testimony of two people, a child that wanted to go home from the hospital and now seeks millions of dollars in compensation. Oh, there's a little, just gotta put that in there, right? She's now seeking millions of dollars in compensation. You mean the jury awarded her $261 million, which is even more than her attorney asked for. So, sucks to be you. And a social worker who was dropped from the lawsuit immediately before trial without a monetary settlement. Well, you know why? Because she's your employee and you accepted responsibility for her actions. And your insurance company is going to pay for whatever she did. Because what's Kathy Beatty going to give you? The keys to her, 1980 Oldsmobile? No. That's not how it works. She's under your insurance. She doesn't have her own private insurance. She's an employee of the hospital. That's how it works. The child has relived these events over and over in her mind, in part because her father's lawsuit has required her to do that. Oh, so now they're blaming Jack for this. Oh, so now her PTSD is all Jack's fault. Because you know what? They should have just forgotten about it. There was no need for a lawsuit. You should have just forgotten about it. Just get over it. How many chronic pain patients have heard that? Just get over it. Anyone? Bueller? Anyone? You like that part too? Yeah, that was a good one, right? It's all Jack's fault we're here. Between the two versions, the weight of the evidence does not support the plaintiff's claim. I disagree. Motion for new trial on excessive compensatory damages. Okay. For this battery that resulted in no bodily injury or need for medical treatment, the jury awarded Maya Kowalski $19 million. Well, again, it sucks to be you. That is an amount that is currently near the outer limit of the award recognized in Florida for the worst sort of wrongful death claim. Okay, we're going to cite the tobacco company claims. Okay, I submit to you again, people who are smokers choose to smoke. That is a choice. That is a choice. Okay, that is a very, very different case. Okay. So don't bring up your tobacco litigation. And besides, if it's the very, very outer limit, it's still within the limits of a sustainable verdict now, isn't it? Oh, yeah. And how about that $1 billion verdict that came out in Florida in August of 2021 for the 19-year-old college student that was hit by a semi-tractor trailer and killed because the guy was texting, and it was $900 million in punitive damages. How about that? Is that shocking your conscience, Hunter? He admits that it's in the outer limits. So, you know who's in the outer limits? Me. I feel like I'm in the outer limits right now. I'm in the twilight zone. I'm in the outer limits. Like, am I the only person who feels this way? Anyone? Hello, Miss Scarlett Hall. Led Peep. Welcome. Welcome. And we have another CRPS warrior. Everyone say hi to Scarlett. My daughter's name is Scarlett, and it's spelled the same way. Mine's a Grateful Dead reference, though. I don't know if yours is. Yeah, the comparison is all about money, Kayla. It's all about money, I think. It's all about, like, well, even these people who died a slow, painful death of lung cancer or COPD or COPD, even those people weren't awarded the kind of money that Maya is going to be awarded. Well, she's going to have to suffer mentally for the rest of her life, emotionally. Not to mention the flare-ups from the CRPS that she already had that you made worse. And all the stress that you're causing her by putting up her bikini picture for 5 minutes at a deposition is still adding to it. So you know what? Keep piling on. Keep piling on, guys, because that's what you're doing. It's the only thing you're doing. You're not helping your client here. This is not helping your client. You know what would help your client? Settle the goddamn case. I'm sorry, I don't curse on this channel. Settle the case. Just settle it. Just be done with it. Stop making idiots of yourself. It's like toilet paper, this motion. So it's near the outer limit. Okay, so it's near the outer limit. So it's sustainable. You just admitted it was sustainable. I don't even need to read the rest of that sentence. And for the 5th time, this jury's award for both economic damages and for non-economic damages far exceeds the bounds of any reasonable range. Well, you just said it was within the outer limits. This award was supposed to be an award of damages only for this tort. As a matter of law, it was not an award for one piece of a huge combined claim for aggregate damage. Are you calling the jury stupid? Because the jury was read some pretty lengthy instructions. They also had a pretty lengthy verdict sheet. So I'm pretty sure they understood. Oh, the court made that clear during the jury instruction conference and prior to the closing. This court believed that the jury would understand this without a special directive on this verdict form. But the jurors clearly did not understand the task they were performing. How do you know? Oh, that's right, because they're a bunch of bus stop people. Scott, my bus driver, are you in the chat? Are you loading up the bus? Who's going to meet me in New York City for a picture in front of a bus stop? We're going to get 6 people. We're going to put them at a bus stop on a bench. And we're all going to wear Team Maya shirts. Who wants to come? I don't know, Jules, what he called you, but I'm going to go back and look for it. You're never going to let me live that down. I just might change my name to that now. I don't know where it is, but I'm trying to find it. Jason, my daughter's name is Scarlet Fire, but the fire is spelled F-Y-R-E, and that's her middle name. How funny is that? Oh, thanks, Callie girl, for your super sticker. I love you. I love you with all of my heart. Scarlet Begonias. Yes, that is right. My daughter's name is Scarlet with 2 T's, and Fire is her middle name, F-Y-R-E. And in my defense, that was in the baby name book. It's Gaelic. It's the Notorious Jules. Yeah, I think we should make t-shirts, right? I know Notorious Jules or something like that. Somebody give me a catchphrase. You guys are good at that. You guys are really good at that. Purple Prose and Gilad, the defense is showing their true colors and pissing more people off. It's not so hard to, it's not, I mean, it wouldn't be so hard to just word this a different way that wasn't so completely offensive to every single person who read it. Like you, I don't even want to say Reddit. Don't go to Reddit. Don't go to Reddit. It's just going to upset you. There are ways of making this argument without, I'm going to say it, without mansplaining, without being misogynistic, without insinuating that somehow, some way, in some alternate universe, Maya should have wanted to sit on Kathy Beatty's lap, and that we should all think that that was totally acceptable, and that absolutely any reasonable person would find that acceptable, because after all, she couldn't have her mother. Kim, I do not think there's any amount of money that could repair the damage that was done to that family. This is also traumatizing the family yet again. Yeah, I hope they're not reading this. I hope they're not watching. But if they are, I'm so sorry for what happened to you and continues to happen to you. And yeah, they just don't get it. They just don't get it. Yeah, Laura, he's a mansplainer. The Notorious Jules rules. I like that one. All right, I'll work on that logo. Unless you want to do it, Kurt. Susan's like, I'm going to the bus stop and take my picture. I'll do it. All right. There's more because, it just can't end there. They have to go on for 144 pages because one of their young associates was not getting a Thanksgiving break. Happy Thanksgiving. Basically, the jury is stupid. They didn't understand it. How could they possibly have awarded this much money? It wasn't really that bad. We didn't really do it, but if we did it, it wasn't that bad. And if it was that bad, it wasn't worth this amount of money. Oh, so they're saying a verdict on both would be $85,000. Probably, it would still be too much, but we'd be cool if you'd just, award $85,000, reduce it to $85,000 because really the jury was not only stupid, but they were overwhelmed by passion and prejudice. Sounds like an Emily Bronte novel. They were overwhelmed by passion and prejudice. Again, the compensatory damages were also too big, Judge. So they gave her, holy crap, Judge, look at what they did. They gave her, I mean, they don't even want to say how much they gave her, but they're saying that, but if you're going to, reduce it, then I think the maximum lawful range for any future economic damages should be less than $10,000 because there's no evidence that this short event of being kissed and hugged and patted and comforted by Kathy Beatty and put on her lap caused or was a substantial contributing factor to PTSD. But guess what? That's a jury question. That's not for you to decide. Hunza. Not for you to decide. That's why we have juries, because juries are the ones who make these decisions, not you. As to non-economic damages, the maximum lawful range for her pain and suffering should be less than $25,000. Okay. Here's where we get to the fun stuff. Intentional infliction of emotional distress. And here's their argument. In count 21C, Maya Kowalski claimed that the defendant's employees engaged in extreme and outrageous conduct with either the intent to cause her to suffer from severe emotional distress or with reckless disregard of the high probability of causing such stress. The defendant would ask this court to read the allegations in paragraphs 239 and 244 to compare the claim as alleged to the claim as presented in the evidence. The allegations are more or less a highly exaggerated versions of the claims for false imprisonment and battery. Highly exaggerated because a reasonable person wouldn't find it offensive. Count 21C claims the defendant put her in a darkened room to torment the child when the evidence from plaintiff's own experts is that sensitivity to light is on the Budapest criteria of symptoms suggesting that a person may suffer from CRPS. Wait, so she had CRPS now? Now you're going to say that she had CRPS? And we were doing her a favor by putting her in a darkened room because it's part of the Budapest criteria? Somebody help me on the Budapest criteria argument. We did her a favor. Yeah, Matt. Obviously, they don't understand the T in PTSD. Matt, sorry, I got it right here. It stands for traumatic. I know, Ron, I'm usually really good about not saying bad words. I try, but sometimes they fire me up. They fire me up. It's like, am I in the freaking Twilight Zone? What, Matt? Matt, thank you again for your next super chat. You had a pain specialist say the same crap yesterday, that it was all in your head. Thanks, Cali girl. I think I got you before. Yes, of course, Dave. Of course the defense helped pick the jury. Of course they did. But they didn't like it. Oh, and guess what else? Juror number 1, the one that they claim is the mastermind behind this excessive verdict. He was the wrangler. He was the one who convinced everybody else to award these crazy, outrageous numbers. Juror number 1 was the first juror to show up for jury duty. He said this in one of his posts. I was the first guy there on jury duty, and I was the last guy to leave. So he really was like juror number 1. I don't know how they do it in Florida, if they put everybody's number into a big bowl like bingo and pull them out and put them in the box. But in New York, you just put 6 in the box, the first 6. And you have their juror questionnaire and you question all 6, use your challenges, and then you move on to the next. and some of those jurors can be seated. So they had every opportunity to get rid of him. He was retired law enforcement, and they thought, in my opinion, they thought he was going to be good for their case because they had some pretty offensive witnesses, in my opinion, that came up to testify. You know, there was a female detective, and it seems like all of the most offensive witnesses were women. I don't know how they found so many mean women to work at that hospital or to work in the DCF or to be like the one who took away the communion wafers because she thought they were dosed with liquid K. They had every opportunity to get rid of him and they didn't. So you know what? Sour grapes, live and learn, move on. Pay. Good night, Mary. It claims that Maya Kowalski soiled herself in the room, in a room with constant video monitoring that shows no such event, and no such video was shown to the jury by the plaintiff. Yeah, because it wasn't bad enough that you put her bikini picture up there and all those pictures of her at the, at homecoming and Halloween. Now we should put up a picture of her soiling herself. In a room with constant video monitoring that shows, and so no. Okay, Jack testified about the event, didn't he? Are we going to just discount Jack's testimony? That's why it's up to the jury. Claims the hospital placed a commode out of her reach as a torture technique when the undisputed evidence established that she needed help reaching a toilet in any of the hospital rooms. I got to read that again. It claims the hospital placed a commode out of her reach as a torture technique. Well, that's true. When the undisputed evidence established that she needed help reaching a toilet in any of her hospital rooms. But you already said earlier that the reason you put her in this room with the video surveillance is so you could catch her in a lie. Am I missing something? Am I in the Twilight Zone? Am I in the outer limits yet? One of the only videos that plaintiffs actually showed to the jury involved a nursing helping her to go to the bathroom. In nursing? No, a nurse. I hate when they don't proofread. The complaint alleges that the hospital isolated her from her family and friends when the evidence and this court's own jury instruction explained the severe limitations placed on visitation by the dependency court. Okay, it wasn't us, it was them. It was the court. You put the wheels in motion with the second call to DCF. You put the wheels in motion and you held her there when she was allowed to leave. For those first 6, I don't care what you say. I don't care. Blah, 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 blah. It alleges the hospital did not provide appropriate medical treatment, which is a claim for medical negligence, not a claim of extreme and outrageous conduct. Okay, well, we're going to get to that one too, so don't worry. There's not even a claim for punitive damages associated with the medical negligence. I don't think you're allowed to. You're not allowed to get punitive damages on a med mal claim. If anybody practices in Florida, please tell me. But I don't think you can get punitives on a med mal claim. Hunter fought for the hospital. Yeah, not only did Hunter fight for the hospital, he fought for them in dependency court. They weren't even a party to the action. And him and Shapiro were in dependency court fighting to keep Maya in and transfer her out of state to another hospital after Beata's passing. They were a non-party to that action. Why were they even there? Am I missing something? Hunter should have been a witness. That's right, Speak Live. I said this. I said this in the beginning. I'm like, why is he allowed to try this case when he's a witness to all of these proceedings? He was involved in this in real time. Risk management was not, but Hunter and Shapiro were. They were involved in this in real time. They're the only ones who were involved in this in real time. And he could be a witness. But once all that DCF stuff was out, he couldn't be a witness. Oh, thanks, Blessed in Texas, for your super chat. Sorry, I'm late. Oh, that's totally fine. You can rewind later. I really got my time because someone's confused. Said I missed this review. Have you seen Jules Hughes? Yeah, we did. We showed that earlier about the bikini pictures. All right. There's not even a claim for punitive. Yeah, right. We already went through that. Okay. As the defendant has tried to explain in earlier filings addressing the similar claims of the estate, this is not a typical claim for intentional infliction in which one very outrageous act is the centerpiece of the claim. Instead, the plaintiff claims that as a series of actions, many by Ms. Beatty, but many by other staff members, were each contributing extreme and outrageous acts made with the necessary intent to cause severe emotional distress. Okay, there's nothing that says that can't constitute a claim for intentional infliction. This claim was badly prejudiced by the fact that plaintiff was allowed to prevent evidence of negligent training and negligence theories that allowed the jury to hear extensive evidence on matters that was not extreme and outrageous conduct as a matter of law. The defendants repeatedly objected on relevance grounds, asking the court to identify the count to which the evidence was relevant. But this court could not sort out which claim allowed the admission into evidence of testimony. So now you're calling the judge stupid? It's not bad enough to call the jury stupid, but now you're calling the judge stupid? But even this court could not sort out which claim allowed the admission into evidence of testimony about various acts that might be negligent, impolite, or rude in this case. But one way or the other, evidence of negligent conduct was categorically irrelevant to a claim based on extreme and outrageous intentional conduct. Even if this claim had been sufficient to send to the jury, the damages for this claim necessarily duplicated damages for the other torts described in the preceding sections of this motion. The court instructed the jury not to duplicate damages. Nevertheless, the jury's stupid, they didn't pay attention, and they awarded another $3.5 million in past and future medical expenses. It awarded an additional $7.5 million in pain and suffering or non-economic damages. So it is the defendant's position that you should tell us that, they admit, it's the defendant's position that while there may be evidence sufficient to support at least one false imprisonment, and even assuming there were evidence allowing all of the intentional tort claims to go to the jury, there is no evidence of acts, individually or collectively, rising to the level of extreme and outrageous conduct. Not even collectively, not even all of these things put together are extreme and outrageous. Such conduct must be conduct beyond all bounds of decency, all possible bounds of decency, conduct that is atrocious and utterly intolerable in a civilized community, and it must be committed with the intent to cause Maya Kowalski severe emotional distress or with reckless disregard to the high probability of causing such severe stress. I'll go with reckless disregard on that one. As a matter of law, neither the jury nor this court can engage in an act of alchemy that transmutes a collection of other acts by various employees that might be negligent, impolite, or rude, so they might be, into the pot of gold this jury awarded in absence of actual evidence of extreme and outrageous conduct committed with the requisite intent. The undersigned attorney who attended most of this trial cannot honestly identify any evidence of even one thing that an employee of the hospital did with the requisite legal intent to cause severe emotional distress. Not even he can find one. Does that shock your conscience? Doesn't shock mine. This court knows. Oh, now he's going to start schooling the judge. Oh, we're going to see how the judge responds to this. Schooling Hunter Carroll. His name is Hunter Carroll, right? It's Hunter and Hunter. Oh, I just made that connection. This court knows it has a gatekeeping function for this tort. Before the court denies this motion, the defendant requests the court to make a finding of fact as to the specific conduct that it believes is more than negligence and more than upsetting conduct. It moves that the court, in any judgment, include as a finding of fact, it lists the acts of conduct that it believes were proven to the level such that the jury could find as a matter of disputed fact that the conduct was extreme and outrageous conduct performed with the intent to cause severe emotional distress or with reckless disregard of the high probability of causing severe distress. The defendant recognizes that the court did not make such a list when it moved for rehearing on the denial of the directed verdict for the similar claims of the estate, but asks for that information again. Are you effing kidding me? You want the judge to do your work? Now you want the judge to make you a list of what he thinks is extreme and outrageous? Wow. Are you kidding? Yeah, Miss Scarlet, I think so. Is Hunter trying to bury himself in JHACH along with that Dracula? Is he retiring or something? Like he's never going to see the judge again, and he just doesn't. He just doesn't care. No, they are causing a severe distress with this motion. He's telling the judge what to do. Give me a list of all the things that you think, so that I bet the judge wishes he never met her. I wow, Hunter, the audacity. I I I don't get speechless very often, as you know, but I think I'm a little bit speechless. I think I'm a little bit speechless. You are telling the judge what to do, demanding that he make a list for you of all the things, so that when they take this to the appellate court, they're gonna have your list in hand, and they're gonna say, "Appellate judges, here's the list that Judge Carroll gave us, and he's wrong on every single point." He's never gonna give you a are you kidding me? I can't I I don't even know if he'll even address this because it's so beyond the pale. If this court actually believes there is evidence in the record of some collective strategy on the part of the defendant's employee, it doesn't matter what the court believes. It matters what the jury believes. They have spoken. The jury has spoken. That's good for merch. Does somebody else have that merch already? The jury has spoken. They've spoken. And there's too many zeros on that for you to deal with. And you know what? That's too bad. It's too bad because it's not the biggest award that Florida's ever seen. If this court actually believes there is evidence in the record of some collective strategy on the part of the defendant's employees to commit acts of extreme and outrageous conduct upon Maya Kowalski, acts that would be the predicate steps to intentionally distressing her mother to cause her to commit suicide, this needs to be explained in this case of first impression. You think? You think Judge Carroll owes you that explanation? I don't think that's how this works. And you've been doing this for a long time. You know that. Accordingly, the defendant moves for a directed verdict on this claim because the evidence did not create a claim with questions of fact. I don't know why this stupid thing is doing. For the jury to resolve on the existence of Maya Kowalski's claim of intentional infliction of emotional distress. But like the earlier claims addressed in this motion, if the defendant is not entitled to a directed verdict on liability, it's entitled to a new trial. Of course it is, because the evidence did not support any of the things that the jury did, because the jury is stupid and they gave too much money. Okay. What is the evidence of conduct that rose to the level of extreme and outrageous conduct? Committee. What? That rose to the level of extreme and outrageous conduct committee with reckless disregard of the high probability of causing her severe emotional distress? I don't think the word committee belongs in there, but in the emergency room, did anyone or anything do anything to this child that fits into these categories? I don't know, aside from telling her that she was not really in pain and didn't need medication. The emergency room doctors wanted to obtain an accurate blood pressure. Even if that did cause pain, it is credible that it was done with that intent as compared to the need to know a patient's blood pressure in the ER. What employee committed an act of extreme and outrageous conduct in the pediatric ICU with the mindset needed for this tort? Once she was moved to the 7th floor, the jury heard of lots of evidence about visitation issues that involved compliance with court orders. The defendant should actually be immune for its attempts to comply with those orders, but it was extreme and outrageous conduct for the defendant's employees to seek to comply with those orders. There is evidence about religious materials that were kept out by DCF. Was it extreme and outrageous conduct to remove the woman with the 3? Remember that woman? She was so kind. We went over her testimony. Linda Brown, I think her name is. Was it extreme and outrageous conduct to remove the woman with the 3-foot religious icon from the room when she did not register at the hospital entrance? Did she just go barreling through some security gate? And was she chased by security up to the room? Did anybody stop her? Because it used to be you could just walk in 2016. You could just walk up to somebody's room. You didn't have to register at any desk. That was like before security, before COVID. The manifest weight of the evidence may not establish perfection on the part of the staff, but simply does not come close to supporting a verdict of liability for this claim. No, reckless disregard. Sorry. Therefore, we need a new trial. Oh, and there's also some prejudicial legal errors here. Because negligent training should not have been allowed in because you admitted the very prejudicial supposed opinions, in quotes, of Dr. Neuberger. Those errors clearly impacted this claim. The plaintiff introduced extensive evidence on purported negligence that confused the jury when searched for the essential evidence of extreme and outrageous conduct required for this tort. Frankly, it appears the evidence was introduced almost exclusively to create confusion because the plaintiffs never even submitted a coherent set of jury instructions for count 14C. Well, your time to argue that was during all of the many, many, many conferences that you had on jury instructions. So there goes that. Oh boy, so excessive. $10.5 million on this claim. It awarded $3.5 million for past and future medical expenses when this amount was not to duplicate a list of prior awards. On the verdict form, the past medical expenses awarded to Mr. Kowalski on the other claims already exceed $1.5 million when the actual medical bills are dramatically lower. All right, well, we talked about this, and I gave you my opinion on this, and I do think that perhaps the only thing that could be reduced here is the past medical bills, because they really, really do need proof of those past medical bills, and I don't know that they had them in evidence. But if they're saying they lumped past and future into one category here, that was on them to catch that before it got on the verdict form. So that is the Clarabella. Give you the lawyers for the night and the Monty Python. 'Tis but a flesh wound. Do you have a shrubbery? A shrubbery? Delusional. I love Monty Python. That's some good comedy right there. Just like this is kind of like good comedy too, because it's just so ridiculous. So again, the past medical expenses could be reduced as against the weight of the evidence. That is one thing that could happen here. If I'm going to be real with you. The future medicals on the earlier lines total approximately $16 million. If she's only 17, who knows how expensive health care is going to get? I mean, have you seen a bill from a hospital if you have insurance and what the insurance company pays compared to what you'd have to pay if you didn't have insurance? Because it's about 10 times the amount. One night in the PICU is like staying 30 nights at the Four Seasons in Maui. That's how expensive it is for one night. Ridiculous. Thank you. Thanks, Patroness Glow. I'm glad you appreciate my humor. Janelle, yes, the meme of the judge going to get the IJ was created by our very own Jason. It made it into the motion. It made it into the court record. It is quite a thing of beauty. And we do have a very good sense of humor here, because if we don't laugh, we might cry. Miku, one bag of a medication that I was using, 4 bags a day for 6 days, billed $30,000 a bag. Yeah, I think they charge you like $15 for a Tylenol in the hospital. It's insane. And if you have insurance, the insurance pays like 10% in full because they have a contract with every insurance company. But if you don't have insurance, that's when you get screwed. They charge you whatever they want. Ray says, "This is the best bus stop I've ever been to." Yep, we even have virtual snacks here. Is Paul still here? Because he was passing out some really nice virtual snacks. We have cupcakes. We have everything. That meme was fine. You know what? I think we should pull up the meme, right? Let's pull up the meme. Pulling up the meme. We need a little break from that. Jason, is it okay with you if I pull it up? Let us see. Jason, are you still here? You cool with this? He's okay. He's the one who emailed it to me, so he's cool with that. I don't want to give them any more, but I mean, why not? Why not? Why not give them a little more? Can you see it? I went and got the IJ documents myself. There's Judge Carroll. There's JHACH on the burning building. Like a dumpster fire would be good for it too. Yeah, Jason's mean that needs to be this year's Christmas card. Isn't that awesome? Let's see if we can change that. There we go. That's better. Went and got the IJ documents myself. And there's Judge Carroll, and he's, I don't know, what does it say there? 12th? Looks like Mad Max. He's got really good hair, Jason. You gave him really good hair. Thanks, Jason. You sent me another one too. I'm going to put that one up too, okay? And Jason, you're really talented. I'm just saying. I know, and they said it was AI, and you're like, no, it's not. It's not AI. ASMR Shapiro. Maya, so glad you made it. The Shopkins are just upstairs, right this way. Yeah. Yeah, that's great. All right, everyone give Jason a round of applause. Yay, Jason. I don't think so. Did you send me another one? Did you send it from a different email? Jason Smith, man, I love that. Like he left his hair. You just gave him a little extra in the back, like he's on the cover of like a Harlequin romance. Fabio or something. Yay, Jason. Our very own Jason Smith making it into the court file. We got Jules making it into the court file. Kurt, I don't know if you're still here, but were you offended that you didn't make it into the court file? Whoop, whoop. Hated his ASMR voice. Yeah, don't punish us. You really don't want to punish us because if you give away our money, you're going to be hurting so many children with cancer. And also, we really can't afford it. And also, we fired Kathy Beatty, or Kathy Beatty no longer works for us. So if you want to punish us for Kathy Beatty, don't do that because she doesn't work for us anymore. So problem solved. Nancy says, is that from Silence of the Lambs, Jason? Thanks, Miku. Oh, don't spit your tea out, but if you do, it's fine. It means it was really funny. Ray, you are so true. It's so true. His ASMR voice somehow was both soft and aggressive. My ears didn't like it. Yeah. What would Shapiro do? Like, seriously? Why would he say that during closing? I don't know. I had a way better closing argument prepared for him, and he didn't use it. Does everybody recognize that Buffalo Bill from The Silence of the Lambs? No, I did not, but somebody just said that. So yes, excellent catch. Can someone make a Shapiro meme, please, for the love of the Traveling Mary? I love the Traveling Mary. And so many people were in the chat that day that we did her testimony and said, listen, Traveling Mary is a really big deal. Like, that is a real honor. If the Traveling Mary is allowed to come to your house and you are brought the traveling, that is like a very, very high honor. So I really loved that woman who came in. She came in with that hat, and she was so honest and she was so kind. Not sure, but your memes are fire. I can't even read that. That's pretty funny. Oh my goodness. Jason says yes about something. Thank you, Matt. Will someone please think of the children? Yes. Thank you, Matt. The children. Please think of the children. Please don't punish us. The dark force. That's right. The dark force was behind her. That's what he should have said. Don't punish us. We got rid of the dark force. We didn't confiscate the communion wafers. That wasn't us. That was Tori Nias. She didn't work for us. Oh, thank you, Susan. Thank you. And the pies, yeah. All right, Jason, you got some good FaceTime on these memes here. And really, that was so delightful. So delightful. We all loved every single minute of that. All right. Back to their ridiculous asinine motion. Let's see if we can, oh, maybe that's good. And the pies. Angela says, I wouldn't let Miss Beatty water my flowers. They would instantly wilt. So long was it by? We have cupcakes here. We have cupcakes. What's your favorite kind of pie? We did that poll the other night. We had a lot of, oh, and then somebody sent me the recipe for millionaire's pie because we were talking about it in the chat and it was so good. Please super chat me a pie. I ate all the pumpkin pie. I got the millionaire's pie recipe in my email today. That was amazing, Stacy. Thank you for that. I don't know, Stacy, are you here? Will what be televised? You know what's going to be televised? The Chad Daybell trial. That's going to be good. Because that was decided today. I was going to cover that today, but then we're doing this. So those were some interesting hearings today in the Idaho courthouse of the same judge that presided over the Lori Vallow trial. And he is going to allow cameras in for Chad Daybell, and that is going to be exciting. Oh, you're sending a new one. Whoop, whoop. All right, might have to take a little break. I will go back to that in a second. Let's just see how far we can get on this. Okay, so the future medicals are $16 million. If the jury had obeyed the law and the instructions on non-duplication, the verdict for past and future medical expenses would have been zero because there's no way that any reasonable person could have thought that any of these things were offensive. Therefore, it's excessive. Please, please, please cut it down, Judge. Please, please. We're going to go bankrupt. We won't be able to help any children with cancer ever again. And now we get to the medical malpractice or medical negligence, as they like to say, because that is less offensive, I guess, than medical malpractice, but that's exactly what it means. The medical negligence claim in count 8 essentially alleges that the doctors of Johns Hopkins, pediatricians, emergency rooms, physicians, hospitalists, intensivists, pain management specialists, anesthesiologists, and psychiatrists failed to accept Maya Kowalski's pre-existing diagnosis of CRPS when she arrived at the hospital on October 7th of 2016 and thereafter, as a result of which they moved her from incredibly high K infusions being administered by Dr. Hannah, weaned her off of all the significant analgesic medication, and returned her to treatment by physical therapy, occupational therapy, and cognitive behavioral therapy. The claim was that the failure to recognize CRPS as the definitive diagnosis and continue a treatment plan based on a continuation of the K infusions, which Dr. Hannah had without dispute declared to have failed, was the basis of the claim of medical negligence. The defendant recognizes that the plaintiff did present expert testimony. Oh, thank you for recognizing our expert testimony. Thank you, thank you, thank you. The following quote experts, oh, here we go with the sarcasm, supported plaintiff's claim. Dr. Pradeep Chopra is an adult anesthesiologist with no hospital inpatient experience for over 2 decades. Because medicine has changed so much in 20 years. You still don't know what CRPS is at your hospital. He does. He opined that the hospital staff misdiagnosed the child's condition and did opine that the hospital should have used a K infusion instead of the therapies provided. Dr. Chopra has not had hospital experience in many years. Yeah, you just said that in the last paragraph. Maybe if you keep saying it, somebody might think it's true. or think your argument has any merit. I don't know. This use of high-dosage ketamine in Maya Kowalski's case was not only off-label, but it involved doses and infusions at a child in levels unheard of by JHACH physicians and staff. Dr. Hanna had given her increasingly higher doses in the weeks preceding this hospitalization to levels dramatically higher than those used by Dr. Cantu for the risky coma. Dr. Chopra did not suggest that the use of K at these levels was common for adults, much less a small child. Nevertheless, he claimed that the hospital's physicians failed to accept the CRPS diagnosis and should have continued the K infusions as appropriate treatment. But Dr. Chopra failed to produce any evidence, as did every other plaintiff's expert, that any other hospital or any other institution in the US, much less Florida, would have been willing to continue Dr. Hanna's excessive K infusion as he claimed should have been the case. At the end of this trial, there was still no evidence that any hospital would then or now have been willing to continue Dr. Hanna's K infusion therapy. Either every hospital is in breach of this generally recognized standard of care as described by Dr. Chopra, or his testimony is simply incompetent. He may be able to express a pure opinion about a form of K treatment for children that he himself has never performed, but that opinion in a vacuum does not establish a standard of care. Well, isn't that a question of fact? That's ridiculous. He's world class. Ruby says the claim was failure to treat to standard of care, not failure to correctly diagnose. Do you remember the show that we did with Dr. Kave about medical gaslighting? So many of you follow him on YouTube, and so I reached out to him, and he came on the show, and we did a whole show about medical gaslighting and CRPS, and this was during the trial. And Dr. Kave has a K therapy center in San Francisco. So it's out there. It may not be conventional, but that doesn't make it wrong. And I don't think that the point was, we're demanding that you do this in the hospital. Let her go. You didn't let her go. If you let her go, she could have. You're telling the parents that they cannot decide their child's medical treatment, and whether you agree with that medical treatment or not, anybody in the chat, whether you agree with it or not, I submit to you that it is a parent's decision to make for their child. And anybody who's ever had a child in chronic pain knows how horrible that is, because you will do anything to take your child's pain away. Anything. It's like, just give me your pain. I'll take your pain. I don't want you to have pain. There's nothing worse than having, and we heard the testimony of how she had to sleep on the other side of the house because she was howling in pain all night, and it would keep the rest of the family awake. Thank you, Blessed in Texas, for your super chat. They failed on CBT and made her do PT in pain while accusing her of making it up. It makes me so mad. They did nothing for her in that hospital. They did nothing. And I submit to you that tell me in the first 6 days, she couldn't have been just discharged to home. Why did she require transfer to another hospital? Is there any medical evidence that says that she had to be transferred to another hospital? That it would be unsafe to just discharge her? I don't know. K treatments have only had low doses have been very beneficial for coping with CRPS. You know what else is really good for? Addiction, anxiety, depression in low doses, and for chronic pain. It resets the neurons or something. I don't know. I don't know the terminology, but it's supposed to reset your pain sensors or something like that. Florida law requires that a claimant shall have the burden of proof by the greater weight of the evidence that the alleged actions of the healthcare provider represented a breach of the prevailing professional standard of care for that healthcare provider. The prevailing professional standard of care for a given healthcare provider shall be that level of care, skill, and treatment which, in light of all relevant surrounding circumstances, is recognized as acceptable and appropriate by reasonably prudent similar healthcare providers. Just let her go home. Just let her go home. It's in the Patient Bill of Rights. She had the right to leave. I don't care. I don't even need to keep reading. Dr. Chopra did not establish by himself a breach of the prevailing standard of care of healthcare providers, similar to JHACH and the doctors who work for it in a hospital setting. Okay, well, that's kind of a spurious argument because you really didn't have a lot to say there, but what else? Oh, here they go. Poor Dr. Eli Newberger, the elderly child abuse pediatrician. The poor elderly child abuse pediatrician discussed earlier has not practiced clinical medicine during this millennium. During this millennium, he has not even practiced during this millennium. Scarlet, Scarlett, Miss Scarlett, I don't know nothing about birthing no babies, Miss Scarlett. He has not practiced clinical medicine during this millennium. Do you think that they were laughing while they were drafting this and like, I'm just going to throw this in here and see if anybody picks up on it? Some of his opinions are discussed in the global section of this motion because they affect every claim, but as a child abuse physician, much of his testimony related to Dr. Sally Smith. Good. He stated over objection that his expert opinion was that Dr. Smith's practice with regard to this child violated the standard of care that had to do with careful and sympathetic attention to a child's presenting complaints, past medical history, and current hospital course with regard to pain, distress, ruptured family relationships, and her request for analgesic medication, where Dr. Smith, with cruelty, with opacity of sympathy, with a propensity to blame not only the mother as a perpetrator, but the child as a willing and intentional collaborator, rather than to understand the child as a suffering individual supported by loving and caring persons. Dr. Newberger's testimony was couched in obviously inflammatory and argumentative language. I don't know. I would submit to you that I have seen far more inflammatory and argumentative language in the body of this motion than I did in that little paragraph that you just quoted right there. What do you think? Gene. Dr. Newberger's probably forgot more than JHACH doctors ever knew. Yeah, Jason's saying, are you kidding me? That guy forgot more last Sunday than any of them will know for their entire lives. Word, Dr. Newberger, word. Jules, it's like the pot calling the kettle black. Hello, pot, meet kettle. Dr. Newberger's testimony was couched in obviously inflammatory and argumentative language, and it had no basis in objective analysis or fact. Okay, we think it does. The publication of his testimony by deposition was properly objected to by defendant, and the court erred in overruling the defendant's objection. But even if this testimony were admissible as to Dr. Sally Smith, Dr. Newberger's testimony was inadmissible to all of the employed physicians at JHACH. His testimony could not form the basis of a prima facie case of medical negligence pursuant to section this and that for the same reasons explained for Dr. Chopra. Okay. Dr. Timothy Brewerton is a psychiatrist with an adult psychiatric certification that does not qualify him to testify against a pediatric psychiatrist. I don't know. I think that's questionable. I think that he could be. Why couldn't he? Psychiatry is psychiatry, right? Does it have to be a pediatric psychiatrist to testify as an expert in a psychiatric matter? I don't know. I disagree with that, but I don't know. Florida can be like the wild, wild South sometimes with their laws. I don't really know. He testified primarily about his diagnosis that the family members currently suffer from PTSD and or depression. He testified that Maya Kowalski sustained PTSD from the quote events, because even though we've admitted to a lot of the events already in the body of this motion, we're still going to call them made up events that occurred during her stay at the hospital. But he did not testify that it was the events caused by the defendant, as contrasted with the events brought on by the dependency proceeding. Okay, but the totality of the circumstances. He didn't have the qualifications to render opinions as to the diagnosis or treatment of CRPS. He could testify that a condition like CRPS could worsen the effects of PTSD, but he was not qualified to testify that anything the defendant did worsened Maya Kowalski's already existing permanent condition of CRPS. Okay, so she has it or she doesn't have it. Which is it? She has it or she doesn't have it. Good night, Jules. Thank you. Thanks for sharing. Thanks for coming in to hang with us. Everyone says, good night, Jules. Good night, Jules. Happy to have you around. Sweet dreams, Jules. Oh, Jules, I forgot to ask you. I want to know if your TikTok is blown up. Good night, Jules. Good night, Georgina. Good night, John Boy. Good night, Mary Ellen. Anybody know what that's from? Good night, John Boy. Good night, Mary Ellen. All right. Dr. Brewerton gave no competent testimony that specifically linked PTSD to an aggravation of CRPS in Maya Kowalski's case, or for that matter, vice versa. You are correct. I think it was Jeanette who said it first. The Waltons. Oh, nope. Kayla. I think. Kayla? Oh, nope. Kirsten. Laura, oh, everybody up here, you guys all got that. You got that. We're all of the same generation. Yep. All right. Good to know. Good to know. My demographic is like 55 plus, so we have all the cool kids in the chat. Maybe 45 plus. Okay. So nobody said anything that's of any importance according to them. He testified to a breach of standard of care only as to an all children's hospital psychiatrist. His testimony was statutorily incompetent in any event because his adult psychiatric certification does not qualify him to testify against a pediatric psychiatrist. Okay, did they object to that when he testified? Did they voir dire him? I don't recall. In addition, Dr. Brewerton made no prima facie showing with respect to causation. Dr. John Wassenauer testified in sum that the pediatricians at JHACH were remiss in not calling him before considering the question of child abuse or Munchausen. Even assuming this testimony was properly admitted as an expert opinion, Dr. Wassenauer's testimony on this point related to the subject of Chapter 39 immunity with respect to both the report of child abuse and the question of Munchausen, which plaintiffs subsequently abandoned. His opinions, if competent, did not relate to the diagnosis and treatment of CRPS. Dr. Tashwana Duncan, a licensed psychologist, and school psychologist, was never disclosed as a standard of care expert and never gave a report pursuant to the court's pretrial orders and guidelines. She was nevertheless permitted over objection to testify as to the standard of care of an all-children psychologist involved in this matter. But thereafter, this court struck that testimony because she was not a licensed healthcare provider under Chapter 766. In sum and substance, no competent testimony was adduced by the plaintiffs that a pediatric practitioner at Johns Hopkins deviated from the accepted standards of care concerning a diagnosis related to CRPS, or if that deviation was proven, that any doctor provided treatment that deviated from the prevailing professional standard of care for treatment of CRPS in a hospital, which was the standard of care required to be proven by the plaintiffs. Cat lady again, Dr. Duncan was another person brought in by dependency court, Pleston, Texas. Do motions this whiny get filed often? No, just about every single day. Just about every single day. They've already filed 3 since Thanksgiving. Oh, congratulations. Happy birthday, Kim. Happy birthday. Age is just a number. Fine wine. Like a fine wine, Kirsten. Like a fine wine. Getting better with age. The older you get as a woman, I think you really start coming into your power, you know? I wish I knew what I know now when I was younger. There's a song in there somewhere. I wish that I knew what I knew now when I was younger. All right, basically they're saying that every single medical expert that testified on the behalf of the plaintiffs was incompetent and should not be allowed to testify. And as discussed earlier, the argument that the doctors breached the standard of care by not providing high-dose K infusion is not only a claim unsupported by the prevailing professional standard of care for doctors in any hospital, but it was a treatment modality that the dependency court never did and never would have authorized. Guess what? They wouldn't have been in the dependency court if it wasn't for you. Because after the first call was case closed, you had to keep going. You had to keep going. Sally Smith had to keep going because she doesn't get paid unless she is needed. So unless she finds child abuse, she's not getting paid. Nevertheless, the jury returned a verdict finding medical malpractice and awarding $4.7 million in economic damages and $22 million in non-economic damages. I guess they thought that you were really, really, really negligent. That's how really, really, really. 1, 2, 3, 4, 5, 8 digits of really. Bigger than a phone number. Well, without the area code. Therefore, we should have had a directed verdict since there was no prima facie evidence of malpractice. Nobody would have ever given her that treatment. There's not a hospital in the world that would have given it to her. And therefore, you should give us a directed verdict on causation. And here they say, it's unnecessary to reach this motion if the preceding motion is granted. Well, thanks for your instruction there, Chachi. But the evidence establishes that while Maya Kowalski was at the defendant's hospital awaiting transfer to a facility with better programs to provide therapy for her condition that admittedly did not include K infusions because no hospital provided such therapy. How did they misstate that? They weren't sending her to a hospital that provided CRPS treatment. They wanted to send her to a psychiatric hospital. And that's what her mother didn't want, because her mother didn't want that on her record. Because then they never would have paid for her CRPS treatment again, the insurance company. Maya Kowalski initially improved, but then regressed to a degree as the stay was longer and she had more contact with her mother. Oh, so now it's her mother's fault. It's her mother's fault that she regressed. And it's her father's fault that she has it now because he brought the lawsuit. They're blaming everybody but themselves. They will accept no liability. It was not our fault. Deny till you die. Maggie May. Were you named after a song too? JHACH needs T's that say, not sad we did it, mad we got caught. That's a good one. Everybody else's fault except for mine, except for theirs. She left the hospital either marginally better or somewhat weaker, depending on which witness is believed. But she was in the hospital for several months, not because the defendant insisted that she stay for treatment at its facility, but rather because the parties and the judge in the dependency proceeding never reached agreement on a place to transfer her. The therapy actually available and provided by defendant while it was required to hospitalize her was the only therapy the defendant could provide. That is also BS. Because if you're saying that how many PT visits did she have? How many CBT, how many DBT, CBT visits did she have? Hardly any. Right, Rachel? Psych hospital also wouldn't have been able to give her as much physical rehab that she needed, but, she was faking that part. So, yeah, whatevs. Totally okay. They make you salty. Okay, no testimony from any expert that it deviated from the standard of care. Well, that's a question for the jury because they believed all the witnesses of the plaintiff and none of your witnesses because you really didn't produce any. In fact, are you even speaking to any of what your witnesses said? No, because we're just talking about Dr. Chopra again. And it says about Dr. Chopra, his opinion was not even based on experience with any other similar patient, let alone a significant population of patients that were removed from high dosage K treatment. The number of patients of any age, much less pediatric patients who have been removed from the type of high dosage K treatment with which Dr. Hanna was experimenting appears to be one. There is no evidence that another patient, much less a child, was given these massive doses of K. Massive, now they're massive. Was then taken off the treatment when he or she required hospitalization, and then years later had symptoms that might have been more aggressive, CRPS, due to that experience. This is not like a family physician that has seen a cause and effect trend in 150 children suffering from influenza. That testimony is not competent. Evidence of an aggravation caused by a breach of standardized care, even if that breach had been proven. And therefore, we also need a new trial. Therefore, you should also reduce the verdict. Here they talk about Sally Smith. We need a directed verdict also on Sally Smith because this court properly instructed the jury that the defendant could only be liable for Dr. Sally Smith's actions as an apparent agent if plaintiffs were led to believe by the hospital that she was its agent and then relied upon that belief in dealing with Dr. Smith as the hospital's agent. Even if the jury were to believe that such was the case, defendant could only be liable for Dr. Smith's actions if at the time and place of the alleged negligence, she was acting within the scope of her apparent agency. I think they showed that. Do you? She had the jacket, held herself out as being an agent. It is very clear that Beata Kowalski had actual knowledge that Dr. Smith was a CPT investigator when she met with her on October 11th. Beata Kowalski acknowledges at the time in an email where she had no reason to lie. Even if she said that she thought that Sally Smith was a CPT investigator, did she have any knowledge about whether or not she was employed by the hospital as a CPT investigator? What say you? Right, Rachel, thank you. The judge said that fact-finding mission of the jury, they found it was true. Christine Hutchings, yes, Dr. Smith was part of JHACH. Kim, did Hunter even listen to the trial transcripts? I think not. Thank you, Black Rose, one of my amazing mods. Ring that bell, hit the thumbs up. I'm Mozzie, 66. David Hughes is an actual partner listed on the law firm. He was referred to during the trial as the fact clerk. Oh my. Moreover, there exists no evidence that the hospital itself held Dr. Smith out as its agent or employee. Yes, there does. Yes, there does exist that evidence. Assuming arguendo that Dr. Smith had possession of and wore a lab coat with a logo for Johns Hopkins, all children's hospitals, claimed by one of Mr. Anderson's other clients, her doing so was not the act of the hospital, but rather of her own conduct. Okay, well, did you allow her to do that? Why did nobody tell her to take the jacket off? Why did she have a badge around her neck that said JHACH on it? Stop it. Just stop it. Just stop it. You're being stupid now. Not only did Beata Kowalski know of Dr. Smith's affiliation and identity as a CPT doctor from the early stages of these events, but Jack Kowalski acknowledged that no one ever told him that Dr. Sally Smith was a hospital employee. Okay. She was holding herself out as one. I don't think it's a requirement that somebody told Jack that she was a hospital employee. From that point forward, the plaintiffs cannot claim that anything Dr. Smith did or did not do was something within the scope of an apparent agency, which they believe was an actual agency relationship upon which they relied. Okay, so again, defendants entitled to a renewed directed verdict as to the issue of this alone. But what is the evidence that Dr. Sally Smith provided treatment without regard to whether it was negligent or not? Admittedly, she did a thorough investigation of possible child abuse by Beata that included an investigation of the child's prior medical treatment and her current condition, but that was as the head of the CPT team. There is no evidence in the medical records of any treatment provided by Dr. Sally Smith. Anybody have any evidence of any treatment by Dr. Sally Smith? Didn't she tell the doctors to start weaning her off her medication? Wasn't that a medical order? Medical information from Sally Smith available to the hospital staff was Dr. Sally Smith's report that was prepared in December, and this court refused to admit that document into evidence under Chapter 39 objection. Oh, here. She thought Dr. Smith had the same opinion as the defendant did about the port in the child's body, but Beata Kowalski refused to allow the doctor to remove the port, which was still in place when she was discharged. She thought that some drugs should be removed from the list of drugs available to her, but the defendant's doctors were already in that process. Yeah, they were in that process because she told her to, right? Didn't she tell them to start weaning her off of all of her meds? Yeah, maybe try to get her off all the meds as possible. If it walks like a duck and talks like a duck, it's a duck. Kayla, that's the point. Isn't Isn't it they didn't say if she was or she wasn't, she acted as if she was, yeah, because otherwise nobody would have talked to her, no parents would talk to her. If she said, "Hi, I'm here to decide whether or not to take your parental rights away. Can I have a conversation with you?" Most people would naturally assume a doctor introducing themselves in a hospital work at that hospital, of course, of course. It's called informed consent, and she did not inform them. Oh, you just said pie? Gee, Jeanette. All right, so I think we can agree about Sally Smith and what she did, and that she definitely held herself out to be an employee of the hospital. And I think that I don't. I think that argument's going to fail. But let's get to I think more and more. But I think that we've resolved that issue in our own minds. Then they also say that Dr. Corcoran should not be allowed to testify about anything regarding management of the hospital, and so all of that stuff should be thrown out. Because negligent training was thrown out, and therefore Dr. Corcoran should not have been allowed to testify about the negligent training and the IJ reports, all that other stuff. I don't know what the court will do with that, because that was too technical for me to get into about whether or not, and I didn't see where they had dismissed that negligent training claim. I don't know if it was on paper. I don't know if it was orally. But I think they opened the door on that stuff with Anderson's testimony. Mr. Anderson's brief testimony in this regard was in passing and hardly a focal point of his testimony. Yeah, because you gave him a 3-page outline and told him what to say. And you told him to refer to IJ reports that you didn't even give him copies of, and Joint Commission reports and CMS reports. And he was told the wrong information. That is totally on you. You dropped the ball. You opened the door, and go scratch. Go scratch. A lot of, yeah, we don't like it, too much money, but I did wanna get to the part about Beata, because that is a case of first impression, and we discussed that while the trial was happening. Oops, come back. The fraudulent billing claim, they awarded $5 million after plaintiff asked for $1. That is something that may, in my opinion, be overturned. And plaintiff even actually did submit a proposed judgment asking only for $1 instead of the $5 million that they awarded, so I think they're in agreement on that. Yeah, evidence of negligent training is Beatty's corrective action review, but they're saying that the negligent training cause of action was dismissed, and yet the judge still allowed evidence in on that, because they're saying common law negligent training should not have been applicable because they are a hospital and they're doctors. But I see what you're saying, because negligent training, Beatty is not a doctor. Yeah, interesting. That's a great argument. I hope they're watching. I hope the plaintiffs firm's watching, because we're helping them write their opposition, although I'm sure they've already done it. I'm sure they're working furiously on it. No bills were introduced. That's all true. All about these medical expenses. So I do think that that may be overturned. Just settle the case. Just settle the case. The hospital needs to stop paying by the hour and just settle the case. They have insurance. Settle the case. Let me just see if I can find that. Okay, this is a case of first impression for this claim of the estate of Beata Kowalski for the unaliving of Beata Kowalski. Says the jury awarded returned awards for both the survival claim and the wrongful death claim based on intentional infliction of emotional distress. The estate must make an election before entry of any judgment. Intentional infliction of emotional distress seeking survival damages. Concerning the survival claim presented by the estate, the defendant has already argued in various motions and in its attempts to obtain special jury instructions that this particular claim is a very unusual claim for intentional infliction of emotional distress. The case law addressing intentional infliction of emotional distress typically presents a scenario in which the defendant has committed one very outrageous act or closely related acts directly involving the plaintiff, and under circumstances where it was apparent that the actions would cause severe emotional distress, and often where the defendant can actually witness the stress occurring. In this case, Beata Kowalski was not even present in the hospital after October 13th of 2016. From that point forward, only Ms. Beatty and perhaps some unidentified employee or two ever had direct contact with Beata Kowalski, and that contact was by telephone or some form of computer communication. The plaintiff's theory is not that one major incident was done intentionally, but rather a number of lesser events created the distress. Thus, the issue for this claim is an attenuated version of the same analysis presented for Maya Kowalski's claim earlier in this motion. Starting with the first week, what evidence is there that some employee committed an extreme and outrageous act beyond all possible bounds of decency, atrocious conduct, utterly intolerable in a civilized community, and did so with the intent to cause Beata Kowalski severe emotional stress, or with reckless disregard of the high probability of causing that severe stress? Perhaps the unidentified person who threatened to have the Kowalskis arrested if they removed Maya Kowalski from the emergency room or the intensive care unit. Beata Kowalski's own email admits that at least later she no longer wanted to remove the child in this fashion. But assuming she was always adamant that she wanted to take her daughter home and someone at the hospital actually threatened to have the parents arrested, would it be extreme and outrageous conduct for a doctor or security guard to call the police under these circumstances? It might be questionable whether an officer arriving on the scene would decide that he or she had probable cause to arrest, but lots of people call the police to allow the police to make that decision. Beata Kowalski wanted to remove a child from an emergency room or an intensive care unit when the treating physician sent the child to the emergency room for care. She wanted to remove a child with no plan for transfer to another unit and under circumstances in which she wanted the child infused with K, and she was a nurse infusionist whose child already had a port installed. As a matter of law in this context, even a threat to have the parents arrested by the police is not extreme and outrageous conduct that cannot be tolerated in a civilized community. Assuming Beata Kowalski was merely strong-willed and very persistent in those encounters, where is the evidence that an employee of Johns Hopkins responded with extreme and outrageous conduct? Was calling a doctor known to be a child abuse expert to obtain advice from her actually an act that a civilized community would not tolerate? The truth is there is no credible evidence of any extreme and outrageous conduct by the defendant employees in their period when Beata Kowalski was allowed by law to enter the hospital. Missing such evidence, the plaintiff has resorted to a great conspiracy based at the very best on speculation and the stacking of the thinnest pieces of circumstantial evidence. Because the doctors were threatened or intimidated by this strong woman, and perhaps because she planned to make some complaint to someone about their treatment of her daughter, the doctors entered into a conspiracy to destroy Beata Kowalski. Because Beata Kowalski was no longer in the hospital, this conspiracy required the creativity necessary to construct a plan akin to a Mission Impossible episode. The doctors, who would have limited contact with Maya Kowalski once she was on the 7th floor, would convince the staff and Miss Beatty to treat Maya Kowalski very badly. This would cause the little girl to tell her father and maybe her brother and other friends about the terrible treatment. They would then go back to Sarasota County and tell Beata Kowalski these stories in a manner so extreme that it would cause Beata Kowalski to suffer from severe emotional distress. With the perfect execution of this plan, the doctor's revenge would be complete. If this version of a claim of intentional infliction of emotional distress presents a jury issue under the law of Florida, the law has gone way too far. There is no conspiracy and there is no competent substantial evidence to support any step in this theory. This court's decision to let old Dr. Neuberger talk about a conspiracy as one of his medical opinions was clear error, and it cannot be the foundation for this multi-million-dollar award. Yes, Stacy, you are correct. They made the assumption that she'd unalive herself and laughed about it. Seems fairly intentional. Yep. Oh, wow, they're laying it on thick. Their argument is going to be that she did not know about those text messages, and therefore she couldn't have possibly known, and so it couldn't have been intentional. They're saying maybe it was negligent infliction of emotional distress, but the negligent infliction of emotional distress claim was dismissed. Pierre, would this case have played out this way if the Kowalskis had a lawyer at the beginning? Would it have mattered? They did, though. I think, didn't they, right when they first went to the first dependency court hearing, didn't they have a lawyer? Do you mean if they had called a lawyer from the hospital, like, right away? It might have made a difference. You could, as a lawyer, you can demand a transfer. You can demand that they let them leave AMA. Yep, they put old in there, Laura. They're not holding anything back at this point. Yep, they hated the family. They said it out loud. Mama Bats, I find it intentional. They did have lawyers, yeah. Did they have lawyers before the dependency court got involved? Like before the shelter order was in place? Within that first 6 days? If they had a lawyer call risk management and say, you can't keep these people in there. They want to leave. They want their daughter discharged. You have to discharge them under the Patient Bill of Rights. They had a lawyer. I don't know. Was it before the dependency court stuff? They even sent a cease and desist from the hospital to Maya's attorney. But was that before the dependency court hearing? That's what I want to know. Within the first 6 days. Right. I don't think they did it within the first 6 days. I think that's what the question was. I think that was Pierce's question. Like, right away. If they had a lawyer right away, would it have worked out differently? And I think, yeah. Hello, patroness glow. So that is going to be the argument. This is a case of first impression with intentional infliction of emotional distress. And, I think if the jury thinks it was egregious enough and outrageous enough and intentional, could an appellate court reverse that as a matter of law in Florida? Anything's possible. Again, the defense has asked this court as part of its gatekeeping function to provide such a list of every act that was intended to cause Beata Kowalski severe emotional distress or with reckless disregard of a high probability of causing such stress. And it says here, because of the negligent training count, which was only dismissed at the end of the trial, after all the evidence of that non-existent claim had been admitted, the jury heard days of testimony about supposed negligence. That evidence may have created prejudice and passion. No, but there's a curative instruction for that, and it happens a lot, where the claim isn't dismissed until the end of the case. That's not the first time this has ever happened. They're saying the hospital put her daughter in a room with a video camera to see whether her behavior was consistent with CRPS. Okay, so you put the commode far away from the bed or you didn't. It's like everything is like, I don't even know how to describe what they're doing here, but it's gaslighting. It's gaslighting me. The hospital arranged for 2 female employees to place Maya Kowalski on a bed in a hospital room in her shorts and brought a photograph her on January 6th. Maybe that would be enough to upset Beata Kowalski, except for the fact that she never knew about the event. It might fly if the judge makes paper airplanes out of it. Hi, Ron. Section 39 gives immunity to all mandatory reporters and to anybody who reports child abuse and any actions that stem from those proceedings. They're given immunity, and none of that evidence was allowed into this trial. Beata Kowalski could be okay. Then it says, except she didn't know anything about this event. The camera with its images was back in storage at the hospital when Beata Kowalski wrote her suicide note after a very stressful experience in court. Beata Kowalski could be totally justified in experiencing extreme emotional distress because her daughter could not come home, because her daughter was upset she could not come home, because they could not be together for Thanksgiving, Christmas, and New Year's Day, and her birthday, by the way, Maya's birthday, because she would have to go to trial and risk losing her nursing license to get her daughter back. But all of that was totally the result of the DCF's dependency proceeding. It is now quite apparent that the jury simply was unable to sort out what stress was attributable to this defendant. The court's rulings limiting evidence about the Chapter 39 proceeding clearly contributed to their inability to understand what it was they really needed to decide. After Beata Kowalski's death, one of the hospital employees used her cell phone to email another employee to say that she had predicted this. That plainly was not an act that created stress on Beata Kowalski after her death. This court has stated that this evidence is highly relevant, but what does it prove? Is it the key to this grand conspiracy? The doctor explained why she said this in a personal text message to another doctor. She had been aware of another parent's suicide many years before when she was a resident. Perhaps the email is some evidence that some employees had some reason to believe they should be careful in their direct dealings with Beata Kowalski, except they had no further dealings with Beata Kowalski. This is not a claim for negligent infliction of emotional distress. Maybe someday the Florida Supreme Court will abandon the impact doctrine, but that day has not yet come, and the undersigned will not celebrate that day if it ever does. Oh, let us know how you feel about tort reform without letting us know how you feel about tort reform. Respectfully, the email here is more prejudicial than probative, and it does nothing to prove a claim of intentional infliction of emotional distress. What say you, my friends? What say you? Because this is one area that is a little bit foggy. And I said from the beginning of this case that I thought that this would be a hard claim to prove under Florida law. And it'll be interesting to see what the court does with that. That's why I just want this case to settle. Again, intentional infliction of emotional distress causing death by suicide. The difference between these claims is that the extreme and outrageous conduct must be of conduct of an even more extreme level such that the conduct can be regarded as a legal cause of suicide. In theory, the conduct could have been very extreme shortly before Beata's decision to commit suicide, or could have been greater because of multiple acts of extreme and outrageous conduct throughout her daughter's hospitalization, and this heightened level of outrageous conduct caused her to be unable to keep herself from committing suicide. The fact that she was never present in the hospital after October 13th is an even greater stumbling block for this claim than for the survival claim. I don't think so, because it affected her. Everything they did affected her, whether she saw it or not, or whether she was in the hospital or not. In the 3 days or even 30 days preceding her suicide, what extreme and outrageous conduct occurred in the hospital that was committed with the intent to cause severe emotional distress, or with reckless disregard of the high probability of causing such distress that would conceivably have been so extreme as to be a legal cause of Beata Kowalski's suicide? What matters were known to her about any extreme and outrageous conduct of the defendant's employees in that period? She learned of the video recording made in October by mid-November. She had an ongoing concern about the defendant continuing to use Ms. Beatty as the social worker, but at worst, that action by the defendant was a negligent act of supervision or training. There is no credible evidence that the defendant kept this experienced social worker on the case intentionally to cause severe emotional distress to Beata Kowalski. Does knowing her daughter was being tortured factor in? Yeah, mama, you're right, Mama Bets. The criminal courts have recognized it with cyberbullying. It's a test case. I don't know what states those are in. And I know what you're talking about where, there were text messages sent that said, just kill yourself, just kill yourself. I don't know what state that was, but again, yeah, those were criminal. And this is a case of first impression. So I don't know how it would fare on appeal, to be honest with you. I do not know. Again, so I think this case should settle. Nobody ever wants to make new law. Because it goes on forever and ever and ever before a new law is ever made. It'll go on forever and ever and ever. Years and years and years. And they talk about how this case took 5 years to get a trial. That's really not a long time. These cases take forever, especially a case as complex as this. They were on the 8th amended complaint by the time this case went to trial. The complaint was something like 97 pages long. And a very complex case. You had COVID in there where the courts were closed for practically 2 years. Nothing was done. So what say you, my friends? If this court does not grant relief on this claim, no rational hospital administrator will be willing to keep a child in DCF custody for any period beyond the point where the child is eligible for discharge to medical foster care. Many families who cannot accept that their loved one committed suicide will believe that they can sue someone with indirect connections to the stress involved in their loved one's life. The court may think this is a sky is falling argument, but Florida law, as now envisioned by this court, is a sea change from how the Florida courts have viewed suicide at all times in the past. If that motion is denied, the evidence is manifest that the defendant's employees did not commit acts of extreme and outrageous conduct that were beyond all possible bounds of decency, atrocious conduct utterly intolerable in a civilized community. The evidence is manifest that the defendant's employees never did anything with the intent to cause Beata Kowalski stress so extreme that it would compel her to take her own life, or anything with reckless disregard of the high probability to cause her to do that. And that's where the rest of this motion goes on and on and on. We are not responsible for the suicide. That would be new law. What is the evidence that shows our crazy conduct? And the rest of this will just upset you if you go back and read all of this highlighted portions. Blah, blah, blah. There's no evidence of extreme and outrageous conduct by any employee of the defendant. They go on and on and on. They just keep repeating themselves over and over and over and over again. And we want all our money back. And if you don't want to give us all our money back that we didn't even pay yet, we want you to reduce all of our numbers and we want you to just let us win, let us win, let us win. That's what we want. We do not like. We do not like the decision. Please, please, please let us just win this case. That's a lot of reading, you guys. Come into the chat. Tell me what you think. Bus stop people begging to differ. That criminal cyberbullying case was in Massachusetts. Okay. Jen, so I may be the odd one out, but I believe deleting yourself cannot be caused by another, contributed to, yes, but not caused. That's where I think this is going to get hung up. Gotta be honest. Was there negligent infliction of emotional distress? 100%. 100%. Did they intend for her to kill herself? Was that the intent? And if that's the law, I think that is going to be hard to prove. Yeah, please hit the thumbs up. I know, I believe it. Okay, you believe it can be caused, but you have to show intentional intent, that was the intent. And if you have text messages back and forth that say, just go kill yourself, nobody cares about you, we all hate you, go kill yourself, go kill yourself, go kill yourself, like this other test case in Massachusetts, you can show intent. I think easier than in a case like this. They were grossly negligent with a wanton disregard, reckless Will the rest stand up? Yeah, I believe a lot of it will. Aside from some of those past medical expenses that I don't think were proven, and even plaintiffs said, just give us $1 for that. Yeah, I feel like what those texts saying they predicted and celebrated, it feels like they wanted it. Yeah. But she didn't know about those text messages. There's so many nuances here. And I think that, if we're going to really be like focused on what the law actually is, you have to sort of separate the emotion from the law, which is hard to do when you're close to a case like this. It's hard for me too. It's hard for me to accept too, but the law is the law, and you have to be able to point to a specific intent on their part or on the part of a certain employee or more than one employee that they intended to have her do that. She did write a note, leaving note to the judge who disregard would not allow her to see her child. Right, but the judge is not a hospital employee, and the judge cannot be sued under Chapter 39. And there was definitely foreseeability. There was foreseeability because I think it was Dr. Tepa Sanchez that testified. One of the doctors testified that when Beata first came into the hospital, she confided in her and said, "Oh, sometimes I just want to kill myself. Like, this is too much. I can't handle this. Sometimes I just want to die." So there was foreseeability there. But was there intent? Jean, but she knew they wanted her out of the picture. And without her out of the picture, then Maya could go home. Yes, but and I'm not saying that I disagree with what she was thinking, but did her independent act of doing that stop the chain of causation or interrupt the chain of causation? It's a very, very tricky area of law. It's very, very tricky. Right, and she's not here to testify either. Yeah, that's true. Maybe she did know, but we don't know what they said to her in private, and they aren't telling the truth. Though I get what you're saying. I'm more asking, not stating I'm right. Yeah, I know, and that's why this is so hard to swallow in a lot of ways. Ridiculous as a chronic pain sufferer and a father of 4 girls is pissing me off. It pisses all of us off. Don't be sorry, Ron. She knew Maya couldn't get out any other way, and they made sure of that. But even after she was gone, they fought. They fought to transfer her to some out-of-state facility. Hunter and Shapiro were in that courtroom as non-parties. Hi, Rachel. Aren't medical professionals obligated to act if someone admits unaliving ideation? It wasn't her treating doctor. I mean, I don't even believe that she really said that to the doctor. So I think that was that testimony was a little bit strange. Patroness Glow, Maya's mom was too desperate to save Maya. Yeah. And she was released to her father's custody within a week of what happened. I think the jury decided, yeah. But the jury decides the facts, and the judge or the appellate judges decide the law. The foreseeability, Mama says, is the problem because I do see their actions as deliberate. Her act might nullify it legally, but morals say it's that. I know. But the morals don't factor in. What they did was horrible and disgusting, and it was negligent, grossly negligent. But was it intentional? That is the key question, and I think it's a hard hurdle to overcome under the law. The jury found it to be their fault, found them liable for that. But under the law, it might be tough. Jeanette says, yes, I don't trust that either. It's just easy to find someone to say that, especially when their job is at risk. Hospitals must conform or be gone. Yeah. Oh, I did see the emails from Beata. I don't know where they are right now, but she did. She blamed the judge for not giving the hugs. I mean, she blamed everybody. Do I think if she moved out of the house, they would have let her go home? Probably not. I don't think so. I mean, I do believe that the hospital set this whole thing in motion. I think Beata's desperate act of maternal instinct. Beata saw her father taken away in communist Poland, to save his family, and she did the ultimate sacrifice, and it worked. But in order to hold the hospital responsible for that, now it's the hospital we're talking about, not the court. You have to show that the hospital intentionally did something with the intent to have her unalive herself. Does that make sense? Misty Ann, God will be the ultimate judge. I think Maya just needed the public to hear the truth. Yes, I think so too. I think so too. And I think that it's brought a lot of awareness to a lot of things. Just don't want everybody to freak out if that part of the case gets overturned on appeal or in some other way. And that's why I wish it would just settle so that it can just be done and they can get some money and they can go on with their lives. And those texts are the key if it holds, but those texts were after the fact. So that's the thing. I mean, there's so many nuances here. The intention was to keep me or mom away from her mother, keep Maya away from her mother. The mother acted on behalf of her daughter in order for her to get care and treatment and to be home. It was sacrificial. Yes. Yeah, I believe, right, Christine, I believe they did intentionally, but I don't know how to prove it. Right. That's what I'm saying. How do we prove it? And we said, yeah, they knew that count could get overturned. It seems like they just wanted a jury to exonerate Beata. Yep. Yep. I think what they did was horrible and it was grossly, grossly negligent. I don't know why that claim was dismissed because negligent infliction of emotional distress, in my opinion, would have succeeded. It's the intent that has me stuck. It was unprofessional, it was immoral, it was gross, it was malpractice on a lot of levels. Shocked my conscience, but I don't know if they can prove intent. Burb Childerly, I come down to, would it have been the same, more or less likely for Beata to unalive if hospital, especially Sally and Kathy, had not set this chain of events and willfully made it more difficult than the court intended? I don't know. Can we prove that what they did, their actions, were intended to cause Beata to end her life? That's the question in a nutshell. And I'm willing to hear anything that you have to say on that front. Miss Scarlett, I don't know nothing about birthing no babies. You're probably too young to even know that reference. Who knows that reference? Miss Scarlett, I don't know nothing about birthing no babies. Kind of hate to say it, but that does make some sense. Such a specific intent to have to prove. Oh, it's about treatments. Miss Emily, does this not come down to how any reasonable people would respond? I think any mother who is under those circumstances would respond in kind. I don't know about that. I don't know about that. I don't know that that would be my solution to this problem. If I found myself in this situation, I don't think that I would do that. I'm not judging anybody who thinks that they would do that. I would fight like hell until I won. But I don't think that I would do that. I don't think that I would want to leave my daughter without me. But that's me, I don't think anybody can put ourselves in the shoes of that person. But in order to prove this portion of the case, we have to show that the hospital intended for her to do that. Mud Swallow, did JHACH have to intend unaliving? No, they had to intend it. That's where this gets sticky. They had to intend for that result to happen. The foreseeable result would have been negligence. Negligence. It was foreseeable. I know. I am a lawyer, a fighter. I know. Yay, got the win, Laura Christine. That's right. Oh, Miss Scarlett, you knew. Ruby, Miss Beatty said, I'll be your mom. I think she wanted Beata to do it. But we have to show that Beata knew that Beatty said that. Do you see what I'm saying? How do we prove that? And that's a good point. That is a good point. It was Kathy Beatty who said that, right? Not Sally Smith. AVR. Totally agree. I don't think many mothers would do that. I think that there are other underlying factors specific to Beata that made her deal and resolve the issue that way. Yeah, I mean, her upbringing, she was raised in communist Poland. You have to take the plaintiff as you find them. They call that this eggshell plaintiff rule or the thin-skulled plaintiff rule. A very simple example of that is if you are in a car accident, you rear end somebody very lightly at a stoplight because you're not paying attention, and you tap them in the rear. If the person driving that car has a pre-existing heart condition and they die of a heart attack, you're still responsible for that death under the law because you take the plaintiff as you find them. But for this specific intentional tort, that's a negligence case, right? A car accident, it's negligence. For the intentional tort, you have to show intent for that result. Standard specific intent, or is it reckless disregard to the possibility of the outcome? I'm going to go back here, but pretty sure that reckless disregard is for negligent infliction of emotional distress, and they have to show that it was intentional. Let's get back to the case law. Everything they said that everything plaintiff said in their closing argument about substantial factor and uncontrollable impulse, all of that was improper and against the law. I mean, against what the law says. And that swayed us. The irresistible impulse. That's what swayed us in the closing, right? They go through all the testimony. It has to be intentional conduct. That's why they're saying this is a case of first impression. Miss Emily Kayla, thank you for your response. I would fight like hell too. I question if the plaintiffs could argue further that most mothers are reasonable until our children are in harm's way. Yeah. I don't know. I don't think any of us can judge. The money connected to that tort. Well, let's see. A lot. There was a lot of money connected to that. Let me just go back to this for a second. $20 million for each child, $2 million. Yeah, so I think they're saying 108 million of it was for the wrongful death. You have to show extreme and outrageous conduct. It's a very complicated legal argument that a judge or a panel of judges is going to have to decide. So the difference, okay, the extreme and outrageous conduct must be a conduct of an even more extreme level such that the conduct can be regarded as a legal cause of suicide. Not saying they can't win. I'm just saying that of all the claims, that's the toughest one. And you have to show that everything that happened was known to her, and that's hard because she's not around to testify about it. If they can survive on reckless disregard, maybe they can, with reckless disregard of the high probability of causing such distress that would conceivably have been so extreme as to be a legal cause of her suicide. What matters were known to her about any extreme and outrageous conduct of their employees within that period. They went through all of that stuff, and then they say, even then, she carefully, it wasn't a rash plan. She wrote the suicide note on a Friday, presumably committed suicide on a Saturday afternoon or even early Sunday morning. She did not rashly grab a knife or gun to kill herself. She carefully executed a plan for suicide based on her expertise as a nurse. Infusionist. And she did this without any direct involvement or encouragement from the hospital. She did it without her family or Dr. Duncan foreseeing her suicide. But this court has decided that Florida law now makes her suicide the 100% responsibility of this defendant under the facts of this case. And they awarded more than $100 million for this death. I'm going to be very interested to see how the plaintiff responds to this portion of the argument. And I could totally change my mind and then be like, oh, wow, of course, of course. So we'll see. It'll be interesting to see what their response is to this, because this is a very, very technical legal argument that is also a very emotional one for all of us. So we'll come back and discuss the plaintiff's response, I am sure, as soon as they file it. And we have some time because this takes a long time because we digress. Speak Life. Melanie Anderson said he got only to present a small portion of the case, that he has as much more. If they rehatch this, can he bring up more things than he didn't get to at the time of trial? Yeah, if the next judge allows it into evidence. Ron, shouldn't have to be intentional. Their actions have caused the unaliving and should be enough. But that's the name of the tort: intentional infliction of emotional distress. That's the only surviving claim for that. Night Owl. JHACH should fire their legal team because they're making the hospital look more and more horrible with every word they write. They can never come back from this. I agree. I totally agree. Courtney, irresistible impulse does not equal instantaneous impulse, just that it was an impulse that she could not resist. Seems like she tried to resist it, but she couldn't. Yes, but they're saying that irresistible impulse was, and they weren't allowed to say that in their closing. And I don't know the nuances of Florida law enough to opine on that. You know? You know? Hi, Mozzie. As XLEO, there is never any rhyme or reason to the way people unalive themselves. Never. Never. Hi, Anna. Can the statement of the psych that diagnosed the major depression and PTSD for Beata could be used as evidence? I think they did use it as evidence. But I don't think she ever told any psychiatrist before that that she was being caused such severe stress that she was thinking about it. No, because then her doctor would have to report that. Did she ever tell her doctor about any extreme and outrageous conduct? I mean, that could be used, but I don't see that. I don't see any of that. What would prove it? Pierre, her stating that she acted to free her daughter? Didn't she kind of say that? But her thoughts Were her thoughts caused by the hospital? Like what would prove it? If somebody was sending you text messages saying, kill yourself, kill yourself, kill yourself. Nobody likes you. Everybody hates you. Just kill yourself. Nobody cares. Those are the kinds of cases that we see with regard to this. Most negligence cases is a death caused by another person due to negligence in an accident, a car accident, medical malpractice. Somebody dies. They cut off the wrong leg. You die during a tonsillectomy when you should not have because somebody gave you too much anesthesia. Things like that where you can show it's much easier to prove a causal connection. Not that medical malpractice cases are ever easy to prove because they're not. But this independent act of her making that choice is what makes it so tough. Does that make sense? They were. I agree with you, American Nana. They were cruel and ugly to Beata. She knew they were evil, and constantly they were ugly to her. They were. They absolutely 100% were. Kate, when does Judge Carroll need to respond to these? Well, I think there's a motions hearing on the December 15th. I don't know if he's going to rule on everything right then and there. But plaintiff has the opportunity to respond to this first. So I'd like to see their response to this. And then we may say, oh, that totally makes sense. I totally get it. Susan, I agree. Also, this case gets more attention the longer they keep fighting. And as long as they keep fighting, Maya, we will fight harder for her. Yes. LB, they thought she had MSBP, a psychiatric illness. Kyle still at home. They did have mandatory reporting. Then Beata would have been committed and everything looked into and alive now. Maybe. I don't know. Can we predict? Do we know with 100% certainty that she did not have any sort of pre-existing depression, that this kind of just pushed her over the edge? I don't know. I don't know. Given she was released very shortly after in an emergency motion to the court ahead of schedule without her being shipped off, it proves her point. Retroactively, hindsight's always 20/20, right? It's just... Janelle, how do you get across to the medical profession how dangerous attacks on someone like this can be? It's horrible. It's hard. The whole thing is horrifying. The privatized DCF system, all of it. It's horrifying. And I think we can all see, yeah, I think, right. I think we can see why she felt that was the only way out. She wanted her daughter taken care of, and she was getting worse and worse. Karen says, does anyone remember that Maya was a miracle child for Beata? It took a long time for her to become pregnant with Maya, and the doctors told that might never happen. Yeah. Miss Emily, that would be explicit, as you are saying, but circumstantial evidence as a whole, I feel there was intention to use this to push her over the edge. It's really tragic. Yeah, I know. They did give her a psych evaluation and she passed it. Anna, sometimes diaries can be used as evidence because you can track the evolution of the mindset. Usually there's a decline. Maybe that could be evidence. Yep. But you have to show intent on the part of the defendant, and the only remaining defendant here is the hospital. So even if you showed that Sally Smith wanted her to go unalive herself, and we could prove that, maybe we could show that she was an agent of the hospital. If we said, okay, well, we could definitely prove that the judge wanted her to do it because he sent her an email saying, go ahead, do it. It's the only way I'm giving your daughter back. Then we'd have some more evidence. I'm just saying that's the toughest part of the case. I hope it doesn't have to get ruled on because I hope the case settles. Everyone should settle, settle, settle. That's all I say for now. Okay, I'm exhausted. I'm sure you're all exhausted. It's very late here in New York. I don't know where you guys are, but oh my goodness, it's after 1. And that's where we stand today. So feel free to, share the stream, like, comment, subscribe, hit the bell, all that good stuff. Thank you all so much for spending this evening with me after the little break that we had. And is there anybody else here that I need to address? I think I got all of you guys. Be kind to each other in the comments because there's way too many mean people out there. So thank you to my moderators for keeping the chat classy. I know this was a very long evening for you, and everybody was so well behaved, so I don't even think that we had to time anybody out or kick anybody out. And I think everyone, Rochelle, you're still here. Oh my goodness. You need to go to sleep too. Let me know what you want to talk about next before something else gets filed in this case and we have to cover it again. All right, my loves, my cupcakes. Thank you so much for hanging in there with me. I will see you again really soon. Just, remember, be cool, be kind, be classy. It's not that hard. See you guys soon.